My lord, item number 27 to 30, my lord.
Huh.
It is admission matter in
Hmm.
where it is affidavit in opposition has been filed by the respondent number 2 and 6.
You want some
I
fine.
want to reply. So that means when urgency is there, it is that may be possible on
Till
9th
30.
9th of December, my lord.
See, fag end. You have it. Or
I
reopen
have
it.
only filed it, then another date will be fixed, my lord. That is right.
Item number 27 to 30. Mr. P. Monto, learned counsel for the petitioners, has submitted that the respondents have already filed their affidavit in the
2 and
matter,
6.
and 2
and 6, my lord.
2 and 6 have filed their affidavit in the matter, and he desires to file a rejoinder thereto, and accordingly prays for a week's time for the purpose. Post up. Prayer accepted. Raised to list this matter. Post up. Prayer accepted. Post up. As prayed for by the learned counsel for the parties, raised to list this matter again on 9/12/2024.
Yes, please. Bas.
May it please your lordship.
Yes.
May it please. With the concern of other side, your lordship, I may make to mention item number 22 and 23, your
Huh?
lordship. 22 and 23. So I have to file a reply, your lordship. They have filed a.
There is a stay here.
Stay, that is IAS.
You have no objection.
Lordship, my senior is also not well, Lordship.
Okay. Who is he?
Lordship, Mrs. A guy,
A guy.
Lordship.
Surgery. How is she now?
She's fine.
Fine.
Lordship, I pray for 3 weeks time.
Okay.
lordship.
Okay.
Yes.
Okay. Mr. D. Bora, learned counsel for the petitioner, submits that he be granted a 3 weeks time to file the response on behalf of the petitioner to the affidavit filed by the respondents. Prayer is not objected to by the learned counsel for the respondents. Full stop. Raised it to list this matter again after 3 weeks on a date to be fixed by.
Matter.
Yes,
Lordship, I beg to mention item number 39, Lordship, and 54, Lordship.
39 and 54.
54, Lordship, in this matter,
Yesterday you prayed for a.
this thing, Lordship. Lordship, in this matter, Lawrence Senior Counsel, Mr. K. Chaudhary is supposed to appear, Lordship.
Okay.
But today he is due to his personal
Okay.
difficulty. Lordship, may kindly take up the matter on 4th of December. Lordship,
No.
there are some
Uh,
urgency.
You are praying for an earn leave. That IA is only for to an extent of grant of earn leave now. Right?
Lordship,
How can I grant you on the first day? We'll have to issue a notice.
Lordship may take up the matter on 4th, Lordship.
On the prayer of the learned counsel for the petitioner, item number 34, 39, along with item number 54. Raised to list this matters again after 10 days on a date to be fixed by it. I've said 10 days, you get your thing done. You express urgency, so I went through the brief
Lordship.
nicely. Okay, fine.
May it please, your Lordship, with the concern of the other side, Lordship, I would like to mention item number 24, Lordship. We need to file a reply in this matter, Lordship.
Earn leave deduction.
Yes.
On the prayer of the learned counsel for the petitioner, who prays for 3 weeks time to file a rejoinder to the affidavit filed by the respondents. Prayer accepted, raised to list this matters after 3 weeks on a date to be fixed by.
Much up.
1 to 2 piece of material. 3 to material.
My lord, this is a compensation appointment case. We can check, we can take four matters together because that more or less, we have to send department more or less, that when the notification we have challenged the appointment, it's the same. So we can go.
Respondent number 9 has appeared.
Respondent number 9.
15 and 9 have appeared. You are appearing for?
When was 17?
Now, what happened actually? Actually, the private respondent not necessary because we can strike off minor. Because in 2 cases, out of 4 cases, 2 cases, they have already notice and served, but they didn't appear. So we are challenging basically that our appointment, not, we are not related with the, what happened with the other private restaurant. They are, only thing is they are appointed, we are deprived. And the affidavit have been filed in item number 6. Where they have shown that there is a vacancy of partition vacancy, still there.
Okay. What is the date of death?
That is, date of father petition.
You are appearing for?
Lordship, I am appreciate Lordship on behalf of
Date of death?
Date of death is 30/10/2014
30/10/2014.
in item number 3.
3. We are only on 3.
Mm.
Now tell me, where is the compassion left?
If you are item number 3,
Oh.
yes. If you also go to the page 44, Annex G. Completion counter. আচ্ছা, আছে নি copy?
Page number?
44.
Yes.
I am directly informed that on recommendation selection committee and as per approval board of director, why division so and so, the following candidate has been selected for appointment on compensation and ground under APDCL competence scheme. So these are the 15 private party, those who have been selected. Our name was not here, and there are 47 vacancies still there. And if you go through that scheme, my lord, that whatever scheme, compensation scheme, I just read out my lord, APDCL scheme, special scheme there.
Now come to page 47.
Yes, lord. Yes. Also, that the candidate management has been not been selected for appointment on compensation under APDCL scheme on the basis of very subject matter purpose APDCL compensation appointment scheme and the principal judge laid down Supreme Court and on Guwahati High Court. In respect of Mohd Kumar Sharma, it is seen that the family of deceased has received a monthly pension of so and so, which appears to be sufficient to save the family from starvation. Otherwise, also casual employee can get a monthly salary amount of 13,000 only. It is seen that after date of late November.
Yes, what do you have to say on this?
My if you also go through that. And if you go through that.
Mr. Goswami, relax. Mr. Somoa, you need not wait for those 1 and 2. We'll finish the list, then go back to that. You're waiting for item number 1. Then you sit down, continue to sit down.
My lord, item number 6. People have to go through item 6.
Okay,
say
make
affidavit.
your submissions.
Yes. They have stated in the affidavit, even after selection of this 15 candidates, even after selection of 15 candidates, there's still vacancy of 47.
We are not done that. We are not on that.
So,
Your father expired on 2014.
14,
We are in 2024.
24.
That is down the lane 10 years. You have
10.
survived for 10 years.
Yes, my lord.
More further, they have given a reasoning in page 47.
14, 47.
What do you have to say on that?
Yes, my lord.
Compassionate appointment is not a matter of right.
Not a matter of right.
Then
Not a matter of right. But
nothing
this
is it.
Yes, my lord. If you also go through that, there is judgment also in Supreme Court also judgment. Okay, Canara Bank versus Chairman Managing Director Canara Bank.
Year?
2015 is 7.
Oh, Supreme Court has proceeded much further than that.
Pardon, they said that the compensation appointment is not a right.
Right.
If you can survive for such a long time, I know the judgment is there.
So, anything more?
And in case of this private candidate, they have been selected from they are same category. They are also part of
Fine,
40.
they got it. We are not interfering with that.
My lord, I just read out, my lord. I just read out, my lord, in one case, this honorable court, Justice Sanjay Medhi has passed some order. I can show you, my lord, that order.
Yeah, please.
this Prantik Sharma case. Item number 6.
Hmm.
This is the judgment, my lord. My submission is instead of they let them consider it, they'll consider it. I have no objection.
Okay. Anything more?
So they let them consider. I have no objection because I cannot, I even.
So item number 3 done with. So item number 3, your grievance is basically that your case was not considered and the grounds given in page 47 is not convincing.
It's not convinced.
Item number 3, no? WPC 5714 2021. Date of death,
What is the
2014.
thing is that, my lord, even now get financial benefit, in this case, all the people are getting financial benefit. So how can we say that they are not, they're still in dire starvation, my lord?
Okay.
And the judgment, even if it is not there, the Supreme Court judgment says that this is not the only sole criteria for determining the compensation.
Yes, Mr. Goswami, what is your ground in the affidavit? Mr. Mitra says everybody is similarly placed. How can you use this criteria for discriminating against him? And in that Annex A, where is the name of the petitioner
Annex A.
of the affidavit?
Yes, Lordship.
Manoj Kumar. No?
Yes.
Yes,
Manoj Kumar.
page 13,
Yes.
page 70.
Manoj Kumar 13. Internal page 13. Lordship. Serial 60.
Okay. Anything more, Mr. Mitra?
My lord, I just press not to consider now, not that is the different issues, but I can just press one judgment actually.
You are at free. You are free to press anything.
Yes.
Never have a reservation.
Then
Okay.
judgment is there, page 13, my lord, page paragraph 13.
Hmm.
It is written, but in your view, the family benefit scheme cannot be a Canara Bank judgment. But in your view, the family benefit scheme cannot in any way be equated with the benefit of compensation appointment.
We'll consider.
Devulbato is there.
We'll consider this. That will not be considered because subsequently Supreme Court has in demonstrative. Anything more? Nothing? We'll pass orders.
But let him consider, let him.
Let us give it a quietus.
Only submission is that vacancy is there. If
Today, after 2014, today 24, we are not permitting compassionate appointment.
yes, madam.
Bound by the decision of Devabrata Tiwari.
Yes, madam, I know. But thing is that my competence is let the department consider it.
Heard Mr. S. Mitra, learned counsel for the petition, and also heard Mr. J.K. Goswami, learned counsel appearing for the respondents. For the respondents number, standing counsel APDCL appearing for the
1, 2, 3, 4.
1, 2, 3, and 4. Also heard Mr.
M.K. Dev.
M.K. Deb.
Yes.
Dev or Deb?
Dev.
Deb appearing for the learned counsel appearing for the respondent number
Number 17.
17.
Yes.
17. Full stop. The other respondents have remained unrepresented. Full stop. As consented to by the learned counsel for the parties, the present petition is taken up for final consideration and disposal. Full stop. The petitioner in the present proceedings has assailed the appointments made in respect of the respondents number 5 to 19 on compassionate grounds on consideration of their cases by the respondent, APDCL authorities. The petitioner has also prayed for a direction for consideration of his case for appointment under the scheme in vogue in the APDCL. Also, the father of the petitioner, Navakumar Nath, while serving as a meter reader under Tangla Electric Subdivision, Mongoldoy Electrical Circle, APDCL, had died in harness on 30/10/2014. The petitioner herein had thereafter submitted his application for being appointed on compassionate grounds. The materials on record reveal that the respondent authorities had considered the case of the petitioner along with a petitioner, the private respondents hearing and others for appointment under compassionate grounds. Also, on such consideration being made, the case of the petitioner hearing was not found to be eligible for being extended with the benefit of appointment on compassionate grounds. Also, what is this committee called which has made this scrutiny?
I know, I just.
No, in Prantik Sharma it's there.
Yeah, mine is a selection committee.
The selection committee as constituted by the APDCL authorities on consideration of the case of the petitioner hearing, had drawn the following conclusions. Page 13. A to A. So, basing on the said conclusion, the petitioner's case was held to be not, the petitioner was held to be not entitled to being extended with an appointment on compassionate grounds. Also, the conclusions reached by the selection committee in respect of the petitioner's claim for appointment on compassionate grounds was also communicated to the petitioner by the respondent authorities via a communication dated 12/4/2021. Also, I have perused the conclusions reached by the selection committee, and on a perusal of the same, this court is satisfied. This court has perused. This court has perused. This court is satisfied that the reasons so advanced the reason so assigned was so assigned by an examination of the financial condition of the petitioner and his family, and accordingly, the conclusion reached by the selection committee would not require an interference. Also, further, it is to be noted that the father of the petitioner had died in harness on 30/10/2014, and by this time around 10 years have already lapsed, and the petitioner and his family members have sustained without being extended with an appointment on compassionate grounds. First off, in this, accordingly, the immediacy required to be adhered for appointment on compassionate grounds is lost in the present matter. Also, support in this connection is drawn from the decision of the Honorable Supreme Court in the case of State of West Bengal versus Devabroto Tiwari and others, reported in bracket में 2023 SSC Online SC 219, wherein the Honorable Court, upon considering its earlier decisions available in the matter, had concluded as follows. A2, A2A. उसके बाद में also, in view of the decision, applying the ratio of the decision of the Honorable Supreme Court in the case of Devabroto Tiwari to the facts of the present case, comma, it is noted that the immediacy having been lost in the present case and the petitioner and his family having sustained over the period of last 10 years, comma, no direction can be issued, no direction is called for to be issued by this court to the respondents to consider the case of the petitioner for appointment on compassionate grounds. Full stop. In view of the above, this writ petition is found to be devoid of merit and the same accordingly stands dismissed. However, there would be no order as to possible. Yes, item number 4.
The item number 4, my lord,
Same.
same.
खाली तुम date of age change कर दो. Father's name. Jiten Laskar, while serving as lineman under Hojai's Electrical Division APDCL, died in harness on 15/5/2020. And where is the disposal?
49.
Huh?
49 is the RTA reply.
49.
49. Yes.
Seema Laskar.
No.
It will be here also.
Simalos. Oh, Simalos.
Seema
Simalos. Simalos.
Laskar.
Yes, maybe. Yes, 49.
It is not here.
Which one, my lord?
No,
The
no. In the writ petition, also it is, I think, page 49 is for another person.
This is the RTI application, yes, RTI. reply.
No, but okay,
We have not filed any affidavit in this.
ठीक है लिखा ना वो जो कोटिंग दिया वहां से नहीं करना है हाँ वहां पे खाली लिखना the also in response to an RTI application submitted in the matter by one Pranjit Bora, comma, the APDCL authorities had informed that the petitioner was not selected for appointment on compassionate grounds inasmuch as on consideration of her of the financial status of the family, comma, it was concluded that the family was not in the need of an appointment on compassionate grounds. So the conclusion, the contention so made in the said RTI reply dated 12/4/2021 being relevant is extracted here in below. A to A. पेज 49। उसके बाद खाली देवव्रत तिवारी लगा के खत्म कर देना। आइटम नंबर 5, जितेन डेका।
Didn't take same one. They have not filed any affidavit.
At least we will maintain parity here. लिखो, father of the petitioner, Sishuram Deka, while working as a lineman under Lonka Electric Subdivision, Nagaon Electrical Circle APDCL, had died in harness on 27/2/2014. And where is the financial condition here? Page?
The RTI application.
Where?
The application. Page 53, 53.
Page 53. ये प्रांजित बोरा था आगे में, ये होगा जीतू डेका। RTI reply to जीतू डेका। 53 A to A। बाकी उसको लगा के कर दो। Prantik Sharma।
Yeah, they have filed an affidavit. They have stated they are still there is vacancy of 47. But they have not disputed that he is not going to get any.
इसको लिखो तो सेम होगा। और सब सेम। The petitioner बाकी एक ही होगा क्लेम सब उसके बाद। The father of the petitioner, late Pradeep Sharma, while serving as a lineman -1 under
Prantik Sharma.
no, your father's name is Pradeep, under Dhing Electric Subdivision, Nagaon Electrical Circle APDCL, had died in harness on 11/10/2014. The petitioner thereafter submitted his application for being considered for appointment on compassionate grounds. Also, the case of the petitioner, along with that of the private respondents number, you are appearing in all cases for respondent number 6.
Not in the last one. Item number 6.
हाँ, ठीक है, नाम देख लेना खाली ना, अगर है तो लिख देना, नहीं तो नहीं लिखना। Private respondents number 5 to 19 and others were taken up for consideration by the selection committee as constituted by the APDCL authorities for consideration of the claims of the claimants for appointment on compassionate grounds. Also, on consideration of the case of the petitioner, the selection committee, having found the petitioner's family to be financially comfortable, had proceeded to reject the claim of the petitioner for appointment on compassionate grounds. The grounds on which the case of the petitioner was rejected for appointment on compassionate grounds is noted in a RTI reply made by RTI reply given by the APDCL authorities to one Prantik Sharma on 20/10/2021. The reply, the contents of the said RTI reply being relevant is extracted here below, A to A, page 55. Also, being aggrieved, the petitioner had approached this court by way of instituting the present writ petition. Also, this court, while order dated 25/8/2023, on considering the submission of the parties to the proceeding that there were further vacant posts against which the case of the petitioner can be considered, proceeded to direct the APDCL authorities to give a fresh consideration to the case of the petitioner against any one of the remaining vacant posts. Also, You filed an additional affidavit here.
Oh, yes, we have filed.
And where is the rejection order?
Rejection order. Page 89. It is another.
Full stop.
Yes,
The
page 89.
APDCL authorities thereafter proceeded to consider the case of the petitioner again in terms of the directions passed by this court while order dated 25/8/2023, and on such consideration being made, while order dated 19/3/2024,
Stated that there are no
for the reasons
provision
for the reasons recorded therein, rejected the case of the applicant herein. Full stop. A perusal of the order dated 19/3/2024 would go to show that the earlier scheme for appointment on compassionate grounds was already withdrawn, and a new scheme namely a new scheme, namely apostrophe scheme for compassionate family pension, was introduced with effect from 1/4/2017. Full stop. As noticed herein above, the father of the petitioner had died in harness on 11/10/2014, and for the last 10 years, the family of the petitioner had sustained without, where there being petitioner and his family have sustained without any member of the petitioner's family being extended with an appointment on compassionate grounds. Full stop. The Honorable Supreme Court in the decision of in its decision in the case of so and so, उसके बाद बाकी एक ही रहेगा. Reject कर दो. Dismissed. Let's see. Side. It'll be. Mr. Metro, you just take it back. You might require it some knowledge. Sorry, can't help it.
Had it been disposed earlier before that, Supreme judgment, then you would have made out different. I was trying my level to get in this state.
Can't help it. Who is appearing for the respondents here?
My lord, I am appearing for the corporation, madam.
Corporation. And the action is by the corporation.
Action is by the corporation.
Now tell me this law. That imposition of penalty of withholding of 3 increments also would be recasting his seniority. Just clarify that law for me. You are appearing for?
The private
Ah.
respondent.
You are beneficiary. Tell me that law. That is the only reason why you have
Only,
detected
yes.
it.
Only reason.
2000 the penalty was.
For
At
three
least
increment-
till 2003, there is a notification of 87. That till 2003, the currency would be there, he would not be considered. But how can that also lead to a
Interest seniority.
depression of his interest seniority?
I even was wondering, my lord.
Huh?
I was wondering, my lord. My lord, the
So
stand,
we'll have to interfere with everything now.
Now, when.
my lord, basically the stand of the corporation is that since that imposition penalty was imposed on him, that is why he loses his seniority, my lord.
No,
That is the,
it cannot be. When were the others promoted?
seniority on it. Yes.
2019, December 2019.
So, yes, madam, what do you say?
We will file again another one additional.
No,
Why?
2020,
Document have to be.
No document is required. You have a document which you want to give. Have it with you. Then. Today we are taking it up for final disposal.
1 week.
He has been, he has been unduly done. He did something. He did something very serious. For that, he was penalized. And thereafter, the penalty period, currency also expired after 3 years, 2003. Now today, even those ACRs are not before this election committee, maximum 5 years. 2019, it will go back to 2019. It will go back to 2014, maybe 2013. 10 years before that, he was penalized. So we'll interfere. We'll ask them to do it afresh. Or Mr. Dhar, promote him with retrospective effect, with all consequential benefits. We'll protect. We'll have it on Friday. Have your instructions. Promote him with retrospective effect. Because your only ground is depression of seniority.
I will seek instruction, my lord, but we'll have to see whether that post is there, because now somebody else is holding
If the post is not there, we will interfere with the appointment of the private respondent.
I think, my lord, because if that post is not available, because there is only single post, somebody else is now sitting there. He was promoted.
Private respondent.
Private respondent, obvious, my lord. So, my lord, if we want to bring him in with retrospective effect, my lord, then
How many posts are there? It's post of UDA,
UDM.
and one of them have been promoted as superintendent also.
Superintendent. In 3 months, he got the second promotion. Divided, flouting the rules.
Mr. Choma is a bad man, that's why.
Maybe, my lord.
You are troublesome in the office. So you are claiming promotion to UDA.
UDA. Well, UDA, that could be considered, I think could be considered, my lord, by the,
But
That person who was promoted, was he senior to you or junior to you?
my lord, everybody is junior to me.
Junior to you.
Everybody is junior to me. That is what I'm saying. Even the person who has given the post of superintendent, giving double promotion in 64 days, he is also junior to me.
So criteria is seniority cum merit.
Yes, seniority company. And if there is anything adverse against me in merit in subsequent previous 5 or 6 years, then that would have been.
And superintendent is also seniority cum merit. So you are entitled to 2. You are appearing for all the 3 respondents.
Yes, 4, 5, 6, 7, 4 respondents.
Okay. Yes, Mr. Choma, start your arguments.
My lord,
Make
I've
your
seen-
submissions.
my lord has seen the,
I have not seen anything. You want to make your submissions, make your submissions.
yes, yes,
This was just a preliminary hearing.
my lord.
Hmm.
My lord, initially I joined as a junior assistant
Hmm.
on 30/7/1990. 30 July 1990. And my date of birth is, my lord, is 1st February 1965. So I'm retiring. on-
Madam, what document do you want to bring on record?
Chief, I'm not aware.
Then don't be aware. Who is there? Who is leading you?
NS Thakur.
If you have something substantial to say, say. Otherwise, we are proceeding. Yes.
Then, my lord,
You have filed an affidavit here.
yeah, they have
One
filed.
affidavit has been filed on 24th September.
4, 5, 6, 7.
Yes. Again, another one additional affidavit is be
They
filed.
took time last occasion. also.
I've seen it. We will hear Mr. Chamunga today. I'll give you time tomorrow morning. You make your submissions. Today, I'm not troubling you. Tomorrow morning, you make your submissions. Yes.
Yes. Now, my lord, what happened during the subsistence of my service?
Hmm.
I was charged with misappropriation of fund, my lord,
Hmm.
and I was punished following a departmental proceeding. Though that was erroneous, but I did not challenge it, so I'm not harping on it.
Hmm.
The inquiry report is at page 15, annexure 1.
This is not the inquiry report. This is the order.
Oh, sorry, I'm so sorry. This is the order whereby, and the punishment is at, my lord, at page 16, third paragraph. In view of the above, on careful consideration and perusal of the records,
and having regard to the evidence and circumstances appearing in the case as well as the submission of the DO as stated above, and after agreeing to the findings of the inquiry officer, the undersigned has decided to inflict punishment under rules so and so Assam Service Discipline and Appeal Rules, withholding 3 increment with cumulative effects. Infliction of this punishment does not in any way absolve the DO to the responsibility of paying so and so, so and so. And I refunded the money and my 3 increments were withheld. Then the important aspect is next is the service rule. If Lordship can see, my lord, service rule, it starts at page 18. And it's a type copy, original is also there. Then my lord will see, I am holding the post of junior assistant.
Hmm.
Then kindly see rule 5, recruitment at page 19.
तुम किसी को भेज दो, तुम वो मारो.
As your lordship got it.
Hmm.
Page 19.5, recruitment, superintendent.
We'll come to senior assistant first.
Yes, senior assistant.
Hmm.
Appointment to the post of senior assistant shall be made by the following methods: by promotion on the basis of seniority cum merit from among junior assistant cum typist or junior assistant of the head office or divisional office who have rendered not less than 4 years of continuous service. I am in service since 1990.
You're in the head office.
I am in the head office. So, my lord, by promotion, I am entitled to get the post of senior assistant. And for the, if lordship read the point 1, para 1, subpara 1, superintendent. Appointment to the post of superintendent may be made by the appointing authority by promotion on the basis of seniority cum merit amongst the senior assistant accountant of the office who have rendered not less than 3 years. So one who can be appointed as a superintendent, he should be served the institute organization as senior assistant or accountant for 3 years at least. Then he can be the superintendent. Or for senior assistant, I should be junior assistant for 4 years.
Hmm.
Then, my lord, next page, page 20, point number C. Accountant. The appointment to the post of accountant should be made by the appointing authority the following methods. For selection from amongst employees of the corporation who have passed BCom examination with advanced accountancy and who had rendered not
That is not required because.
no, my lord, I'm challenging the promotion
Okay,
of others also.
okay.
Because this person who has been appointed as an accountant, he does not possess the BCom degree. And he does not, since he does not have the BCom degree, he cannot have the advanced accountancy also. And
That
he
is
does not have
respondent
the,
number?
pardon,
Respond number?
this is my lord. Respondent, my lord, Amitavanath.
6.
Okay, that will come when it is.
Yes.
So what happened thereafter?
My lord, the post of accountant is like that only. How they can be promoted. Then
Gradation list.
Page 32 is the gradation list.
As of?
This is perhaps 2019.
19.
Page 31.
Before the promotion.
Page 31.
So here the petitioner is at serial number 3.
I am serial number 3.
Where are the others?
The serial number 1 person that he is retired.
Okay.
He has already retired. There is not even a party here.
Then the private respondents?
All of there, rest are there. Here in this, from this list, person number 1, serial number 1, he retired. Umakanto Dihinya. Can you see the date of joining? I'm just saying.
Am I looking at, I'm not seeing it kindly, I'm looking at very unkindly. You get a feel like that, no?
No.
Okay. Yes.
Then my lord, see the orders
Hmm.
of promotion.
Hmm.
Page 33.
Hmm.
On the seniority cum merit basis. That the first sentence itself is, my lord, on the seniority cum merit basis, the following employees of the corporation are hereby promoted as follows. Sri Umakanto Nihingia.
Umakanto Dinga, we are not concerned.
No, I'm coming one by one. Accountant, head office, Assam so and so is promoted to the post of superintendent.
Hmm.
Srimati Bhadravati Devi, stenographer, grade 3. She is also not in our line. Satish Chandra Das, junior assistant cum typist, head office, Assam State Development Commission, is hereby promoted to senior assistant in the head office of the corporation, so and so. Then Salimuddin Ahmed, junior assistant head office, Assam State Development Corporation for OBC is hereby promoted as a senior assistant. Amitabh Nath, junior assistant, Assam State Development Corporation OBC, post as accountant. This Amitabh Nath is a BA. It's not BCom. That can lordship can see from page 32. Last column.
How many posts of senior assistant are there in the institution?
My land friend, Mr. Dhar can.
Why are you there?
I hope, I do not.
Why have you not taken that instruction?
That's correct, Millet. I'm sorry, but since they have promoted two persons to the post of senior assistant. And this Amitabh Nath, who was appointed as an accountant on 2 December 2019, been again promoted on 1st January 2020.
Promoted as
On 6th January,
superintendent.
Umakanto Dihingia, Assam State Development Corporation.
You
Office
come
is
to
hereby-
page 37.
District Manager, Umakanto Dihingia will leave, my lord. Now he is the retired
Come to page Umakanta Dinga, we are not concerned.
37, page 37.
Huh?
So Amitabh
Amitabh
Nath,
Nath.
accountant, Assam State Development Corporation is hereby promoted to the post of superintendent.
Hmm.
In my lord, in less than 30 days,
Hmm.
he has been promoted to second time.
Okay.
And Subhanti Das also.
Hmm.
State of junior assistant was promoted to the post of senior.
What is the stand in the affidavit?
Nothing, my lord.
No,
Well, they have
Post-
written
on
something.
the State stand
It's
of,
blank affidavit.
no, the
Oh.
stand of the government is that I lost my seniority because of my
Show me,
punishment.
show me.
That is the affidavit filed by my brother, Mr. Third.
Be careful, Mr. Dhor. Brother, be careful.
I will not use the stay. What stay prior? The dangerous affidavit.
Okay,
he has
para
filed.
6.
Para 6. The new law has been developed. This is the stand. That I lost my annual increment, so I lost my seniority. And the rule is seniority cum merit. That is why I'm left out. Somebody got double promotion in 30 days and I'm left out.
Okay. What is the stand of the private respondents? Amitabh Nath. Have you taken a specific plea in your petition that he did not have the qualification?
Yes, yes.
Para? Para grounds.
Yes, ma'am. Page 10 of my writ petition, Roman 3, Amitabh Nath, private respondent number 6, could not be promoted to the post of accountant. C, since he does not conform to the specific requirement of educational qualification required for the post of accountant. According to the Rule 5C, one has to be a commerce graduate having advanced accountancy as a subject.
How was it dealt with
By?
in the affidavit filed
No,
by
no,
the?
no reply to this. Nothing. They cannot even, because he's a arts graduate. They have said the total go by to the whole rules.
So this is your case.
My lord.
Okay.
If lordship, not at all required, but if lordship would like to see me.
Hmm.
A small judgment from the Honorable Supreme Court which says, my lord, that stoppage of punishment cannot be a ground for losing seniority. If lordship wants to see me.
Which is the citation?
1995 supply 2, SSC 140, paragraph 4.
Party?
Party name is Muhammad Habibul Haq versus Union Evans. I can give it. Paragraph 4, well, I have not marked it. Paragraph 4, page 142. The sentence starts, Presentum B, Miller. Presentum B. The High Court failed in error in considering that there was a punishment imposed upon the appellant in order dated so and so. It is seen that the punishment imposed was only reduction of scale of pay for 1 year with cumulative effect. That does not have the effect of reducing his seniority, nor would it be a punishment of reduction of seniority of any placement which the appellant would be entitled to hold in the order of seniority.
Okay. Yes, ma'am. Yes, Mr. Dhar. Anything to add?
My lord, regarding why respondent number 6 was promoted, my lord, in para 9, my lord, we have answered it in our affidavit.
But you have not dealt with the question. You have said there is nobody there. That is the second promotion you have dealt with there.
Second.
Because there is nobody in the higher forums, higher post. So we require somebody, so we are promoted.
He was the only person, my lord, who could be promoted.
I was also there. I am also BA.
You have completed or you have something more left? Sit down then. Mr. Dhar, the person's very promotion as accountant is questioned because your rule says that he should be a commerce graduate.
Well.
So how can you give him double benefit when his initial promotion as accountant itself is in doubt, in violation of your rules? And if something is in violation of the rules, recruitment rules, that is void ab initio. I'm giving her an opportunity tomorrow to make submission at 2 o'clock. You also make your submissions at 2. Okay? 2 o'clock tomorrow. By slip 2000. Madam, no adjournment. You will have to satisfy me that the promotions of respondent number 6, he had the qualification of commerce. Recruitment qualifications cannot be. Because we are interfering with the denial of promotion to him on the ground that there was a loss of seniority. That is not called for. He has supported it with the judgment also. Now you protect your promotion to accountant by showing that you had the qualification. Other two will go. Otherwise, we'll interfere with Amitabh, not because he's the junior most. We'll interfere with that. We will say that he should be promoted. And for the superintendent post, they will make fresh consideration. This would be the step of mind. Right? Tomorrow, 2 o'clock.
Well.
Mr. Mahmood, who is opposing you in this matter? Who is the respondent?
Respondents are.
Mr. Dhar, you are appearing?
My lord, I have come to know the PWD, the party here,
Mr.
Name-
Chaudhary is here.
name is not shown, though,
No, Mr. Chaudhary gets to know about everything.
BTAD.
What is this regularization
Similar-
subject to?
Similar order is there, and as well as my
lord,
service
my
was
prayer,
regular.
my prayer would be, my lord. Let me get an instruction, my lord. Today I have come. There is another matter, my lord.
Hmm.
Item 15.
Hmm.
There are the regularization order, my lord, in the
Huh.
writ petition. Now, we have instruction from the government that he was never regularized. The executive engineer, they regularized without any authority, my lord. So, my lord, I also want to get an instruction in this case, my lord. My name is not shown in the cause list. So, my lord. let-
Okay, Mr. Dhar, don't worry. We'll give you that time.
Can you
Any
see-
instruction, Mr. Chaudhary?
Lordship, at present, Lordship, I do not have any instruction
Hmm.
about the present status.
Hmm.
Lordship, may give me.
Now, the executive engineer had regularized his services.
Yes.
Admittedly, the executive engineer did not have the power.
Yes.
But he provides therein that is subject to approval of the secretary. Now, whether that approval was taken.
Lordship, just a short time, Lordship, since it's an old matter.
Mr. Mahmood, we'll give some time to Mr. Dhar. Because the matter was sent to the secretary. What happened? Because otherwise this order is not valid, Mr. Mahmood. Executive engineer cannot on his own regularize somebody.
It's true, but matter of 2000, this regulation of 2000.
I got it.
21
But if
years
it
they
is,
have-
if it is void, if it is without jurisdiction, yesterday also Supreme Court has said a decision, they forced it.
Apart
cannot
from
be.
that matter,
Hmm.
if we forget about all this,
Hmm.
even then 31 year service. And there is the
No, if
order.
there is no regularization, I'm sorry, it cannot be.
My lord, here is a bunch of cases, my lord, where government has been ordered to consider their case for providing pensionary benefits.
Without regularization,
Yes. that-
without regularization.
Yes.
Sure.
Large number of cases have been disposed of together. And Supreme Court also said, if a person has completed 21 year, 20 years of service or more, then he should be regularized.
The second question.
Last two pages maybe. so.
This is just an observation. Literally the writ petitions have been dismissed following Upendas. Says finally that if some work charge employee has been given, so consider the case of the petitioner also. Petitioners.
I also want that.
You're not a work charge employee. Oh, you're a work charge employee.
Yes.
Okay. Sorry. This is observation. It's not binding. Upendas is binding on me.
Observation of the court is also binding upon government.
No, if it is,
On the basis
if there is a
which
division bench holding the field,
a large number of judgments have been quoted.
the
and they
court
are-
has not accepted any of your Supreme Court judgments. It says Upendas will hold the field. Only a final observation was made that similarly situated persons have been
provided.
given. So consider their case. I want to pass a direction that if Mr. Mahmood is entitled, give him. No consideration. Give him. If not, don't give him. Heard Mr. M.U. Mahmood, learned counsel for the petitioner, and also Mr. B. Chaudhary, learned standing counsel BTC, and Mr. R. Dhar, learned standing counsel PWD, along with Mr. R.K. Talukdar, learned counsel, standing counsel accountant general. The learned standing counsels for the PTC as well as the PWD have prayed that they be granted further 2 weeks' time as a last chance to receive instructions in the matter pertaining to the contention made by the petitioner in the writ petition by referring to office order dated 25/2/2000 issued by the executive engineer PWD Kokraja Roads Division that his services were provincialized, but the same was made subject to approval of the secretary to the government of Assam PWD Public Works Department. Also, it is the specific contention of the respondents that no such the order, the executive engineer is not conferred with the authority to effect a regularization of services of muster roll workers. Also, on the other hand, Mr. Mahmood has expressed an urgency in the matter by contending that the petitioner had already retired around
In 21.
3 years, 4 years, 3 years back, and accordingly, he is in need, urgent need of his pension and pensionary benefits. Full stop. In the above view of the matter, the registry is directed to list these matters again on 18/12/2024, on which date the learned counsel for the respondents in the Public Works Department and as well as the BTC shall complete their respective instructions.
The name of SCPW.
The name of SCPWD be reflected in the cause title, cause list.
All right.
Let us have it, Mr. We'll see.
The matter pertains to payment of pensionary benefits, my lord, more particularly family pension, my lord, to the wife of the deceased employee.
Everything is very murky.
My lord. My lord, the only reason why pension has been denied
Is the
is
father's
because of
letter.
a letter which
By
does
the
not
father.
have any sanctity of law. Lordship may directly come to that letter, my lord.
But even here that now that he has given, how can we take that into face value?
My lord.
The page 77 affidavit.
Yes.
How can we take that into
So
face value?
My lord may not rely on that affidavit. First, my lord may kindly come to the.
But what is the there is a assertion that you were divorced in 1997.
Yes.
Has the department made any effort to ascertain that fact?
Lordship,
Perhaps, my lord, from the records, it can be shown. My lord may.
None.
I'll show from the records, my lord may inquire.
Now you have brought on record the maintenance case
Yes.
orders.
And other documents also I'll show.
Yes. Have you made any effort to ascertain whether the father's contention that his daughter, that means the petitioner herein, was divorced from her husband, the government employee in 1997?
In the year
that I don't know,
2002.
Lordship.
Then,
That
then-
instruction I don't have,
then
Lordship.
why, how can you, now they have withdrawn it, this letter goes. So she'll be entitled.
Lordship, but
First,
the
kindly.
copy of the reply has not been submitted to us, Lordship. Not been served on us, Lordship.
Why?
The reply was filed long time back.
12 March.
March.
That has not been served, Lordship.
Mr. Monto,
Well-
serve a copy.
Well-
I've seen it. I've gone through everything.
My lord, they kindly produce the letter, my lord. It's addressed to the Honorable
I
District
got-
Judicial Magistrate. There's no.
Forget
post
it.
such as-
The letter itself will be yours, that contention, whoever has drafted this affidavit, subsequent affidavit, has really applied their mind.
Yeah.
Because the point pointed out is that the signature of the father was obtained on a revenue stamp. A revenue stamp would come in during financial
Financial
transactions, not
Exactly.
for writing a letter,
And
normal
one-
course.
One point which would clinch the issue, my lords. My lords is aware of 125 proceedings for maintenance, my lords. The meaning of wife is there in 125. It says it can be a divorced wife, but if a person remarries, he's not entitled for maintenance. And the records would show that the husband was paying maintenance.
No.
till the year
No,
2019.
for the purpose of pension, Divorce is
Yes,
enough.
yes, no, I'm not on that, that's not on divorce. The fact that she has remarried in the year 2002 stands belied due to the fact that the husband itself was paying maintenance till 2019.
Mr. Monto, not very, it's not the normal course of things. It can happen the other way around also. We have experienced that also. Okay, you serve a copy.
I'll serve a copy.
Mr. C. Sharma, Learned Counsel appearing for the
6 to 9, Lordship.
Dima Hassau. Respondents has submitted that the reply, affidavit in reply filed by the petitioner on 12/3/2024 has not been furnished to him. Also, Mr. Mahanta undertakes to serve the copy of the said reply on the Learned Counsel for the Standing Council, Dima Hassau Autonomous Council during the course of the day. Also, Mr. C. Sharma further submits that he would receive instructions as regards the inquiry, if any, made by the departmental authorities in pursuance to receipt of the communication dated
It's undated, my lord.
communication available at Annexure 1 to the affidavit purportedly issued by the father of the petitioner herein, intimating the father of the petitioner hearing. Also, in view of the above position, registry to list this matters again after 4 weeks on a date to fix by it. On the next date, the Learned Standing Council, Dima Hassau, he is an autonomous council, shall apprise this court of the steps of the inquiry undertaken by the departmental authorities in pursuance to the receipt of the above noted letter from the father of the petitioner hearing.
Can it be before the vacation? My lord? You can give it a try, my
Let them have that. Let it be given a clean sheet.
lord.
Because if they
Date,
come
my
up and say there is nothing, that is the end of the
lord.
matter. Otherwise, see, you have this, then the withdrawal, it gives rise to some doubt.
That, I'll try and
So,
satisfy. my
no need, you need not. They only will have to, otherwise you are through. Only they'll have to show us that we did not make any inquiry. That is the end of the matter.
lord. So in that case, a date, my lord, whenever it is fixed after vacation.
Later, I'll give you. 4 weeks of
I'm very grateful, my lord.
It will last as agreed to by the Learned Council for the parties. List again on search.
Deeply obliged.
Obliged.
I'm coming against imposition of penalty. Fact leading to passing of this order, Lordship, will find from 7/1/2019 to 5/10/2020. Fif- 15/9/2018 to 6/1/2019, Lordship. He was absent.
That we did not go into, that is already regularized.
That is regular. The subsequent part is on the very next day, on 7/1/19.
Yes, what is your submission?
So I have repeatedly asked them to allow me to.
Departmental proceeding. Case of departmental proceeding,
Yes, ma'am.
a form of a penalty has been issued.
Yes.
So show me the show cause first. Why is it bad?
This is the so-called Lordship, page 54.
I have it.
And my reply is at page 56. They-
So charge is unauthorized absence with effect from 7/1/2019.
Yes.
Hmm.
The very charges they have brought, it is unfounded, Lordship, because after recovery, I repeatedly requested them to allow me to join. It is not me, they have not allowed me to join. And thereafter, I was referred to the medical board.
Where is your this joining letter?
Lordship?
Joining letter 7/1/2019.
7/1/2019. Page 30. 32.
Mr. Bora, we are taking it up for disposal.
Lordship can take up.
32.
Page 30.
Okay, show where it was received.
Lordship, Page 33 is the original. On the top, the seal is there, and there is a note of
Okay,
assistant engineer, perhaps it is not
Okay.
allowed to join since he is about
then what happened?
thereafter. Let's see, I was referred to the medical board.
Where? Medical board.
Medical board.
So when you joined on this date, your earlier period was not regularized.
Yes.
When was that period regularized?
Earlier period was regularized. Let's see, on recommendation of the medical board, it is page 40. Right, 44.
Page 44, yes.
19/12/2019, it was regularized.
Hmm.
Even after regularization, I have submitted another application 6/5/2020 to allow me to join.
So they have not allowed you.
That they have not allowed.
Okay.
Again.
Then what happened?
17/8.
Okay, fine. Then finally, the department proceeding was instituted. When were you allowed to join after this?
After 5/1/2021. Like,
Immediately you joined.
yes, on the
6/1 you joined.
6th.
Okay. So your now payment is due from 7/12/2019 to 5/1/2020.
2020.
Okay, what is the wrong in that page 57 order?
Unauthorized leave, Lordship.
What is the wrong? This is the order under challenge.
Yes, Lordship.
What is the mistake?
Absent is there, but in a departmental proceeding, they have to show that this is a willful absent, Lordship.
There was no inquiry.
No, Lordship, willful absent is not there, Lordship. I have repeatedly.
Are you sure there was no inquiry? Not prepared.
Lordship. This is,
If you're not prepared, I'll go for some other matter.
but this is the so-called, Lordship will pay 54.
I'm asking you, what is the error in page 57? Okay, you have nothing to say.
No, Lordship.
We'll ask then Mr. Bora. You have nothing to say?
So
You have accepted this. This is a correct order.
No.
57. Why should I go ahead? You have accepting. I'll pass the order that you are
No, Lordship.
accepting.
I have challenged this order because
Why? What are the grounds of challenge? That is what I'm asking you. What is the error?
Lordship, to impose a penalty, because they have taken that to my reply, Lordship, with only one single line, that is page 56. Here, I have given a reply to the show cause notice. They have taken it is to be an admission, Lordship.
That is what I want.
Yes.
Now you can sit down. Yes, Mr. Bora. You have initiated a charge sheet against him.
No.
Proceeding against him. Where is the conclusion?
No, my lord, page 56, the reply.
Where is his admission in page
My lord,
57?
in the first paragraph, with due respect, page 56, my lord, with due respect, I have the honor to inform you that the charge sheet and the statement of allegation received accordingly. As per the statement of allegation is true and charges framed against me. We say admitting that this is true. So the
No, come down. Come down. Come down to the third paragraph.
So I applied for joining in my duties on 7/1/2019 after availing the leave from the allowed to join the concerned superior. That after another joining
He is
letter,
a peon. We'll have to understand his English in that manner. But third paragraph he has said. And if you come to page 36, 33. It is clearly written there that he should not be allowed to join.
Because
How can a peon go and join when you're, because after page 33, the period of his absence, you sent him to the State Health Board, confirmation received. Thereafter, that period regularized, commuted leave given. But he is waiting, he has already submitted his application for joining on 7/1. And that is the starting point of unauthorized absence in your letter, right? Merely because of the first paragraph, which is nothing. Admission should be categorical.
he has already. the
He
charge-
has said, see, how can you do that? Because I am waiting. And why only till 6/1/19?
He gives he makes an application and he
Ah.
releases. He's the habitual absentee. He gives the allegation.
Where is that finding? Where is that finding? Where is that letter issued to him that you have not joined? Rather, the thing is, don't allow him to join. Send him to the medical board.
That is there, my lord. Not the in the so-called he has a reply he has admitted, my lord, in the very first paragraph, my lord. That's why, my lord, ultimately the order was a very lenient order, my lord. He was allowed to join and that
No,
party.
if this is unauthorized, you will have to declare, you will have to come to a conclusion that this period is unauthorized. You have not come to that conclusion.
My lord, that the order, my lord. The
Have been
charges of
gross, where is this admission? That true? He said, he may be even saying, okay, there is a charge like this against me. It is true.
true. They have
Fasa.
admitted.
If this is, you have written it in English, not in Assamese.
Written in
English itself.
Though this is the original one, my lord. And the charges of gross negligence and duty, indiscipline and subordination.
This is as per charge which so and so is true,
Admitted.
charge framed against me. He might have said what he might have intended. Yes, there is a charge like this framed against me. Nothing more than that. Because third paragraph, he gives the answer.
Subsequent line.
Third paragraph, my lord,
I was waiting for this from Mr.
he
Doctor.
is waiting, but he.
No, I was waiting for this only from Mr. Doctor. We are interfering.
My lord, since it has not been admitted, my lord, the charge.
It's not admission. We hold it that it's not admission. Admission should be categorical.
Because in the very first paragraph, he said that
No.
then little bit of dilution here, he is waiting for that. But the first paragraph, he said.
But see, if I read it, that's why I asked him, where is your joining report? Page 33. Clear cut. And the documents thereafter shows that you have been sending him for examination by various medical authorities.
Because there is
That means you have caught hold of him, you have not allowed him to sit.
initially the no leave was taken. That's why that.
Be that as it may. But he was there before you.
But he was.
This whole delay took place for your decision to arrive at a decision as to how the earlier period would be regularized. Now, the earlier period has been regularized.
That had been regularized.
If it was unauthorized, should have been the whole period. Because 7/1, he is there.
Yes, 7/1, he is there, he 7/1, he gives an application. The process that he is the habitual one, he gives an application, he gets.
Where is your finding? That is an habitual one.
In the affidavit, I have stated that he is the habitual.
The affidavit we will not do. Even in the charge, there is nothing.
No, there is nothing.
Then past conduct is not there. So, this order will go. Give him 50% back wages.
Because without working, he will get that, but
Yes. You have facilitated that. Or show me a judgment that this will do.
so then the lawsuit will fix it and I will go.
No, today itself. I can give you time till 2.
My lord,
2 o'clock, not more than that. I've heard this time. I've spent time here. I'll finish off the matter.
let it be day after tomorrow.
No. Day after tomorrow, my people all are going. I'm not here. 2 o'clock. You get me a decision. That admission should be categorical
Yes.
in a department.
From
person.
the
There are-
entire content of the document, it has to be covered.
Huh?
They have just sketched up one single line, but content
That
of the
single line
document
you
is
have
other.
written. Why did you write that line? What is your explanation?
But from the content of the document.
No.
entire-
What is your explanation? I gave an explanation. I took out what is your explanation? 2 o'clock, give me an explanation to that.
Lordship.
If you are insisting on that. Now we will go only after we hear your explanation. That second line explanation. So Bora,
Okay.
give me a judgment if you. We'll finish it off. We'll finish him off. But otherwise, he's getting it. Subject to his clarification with regard to the second line. Okay.
Okay.
2000. Disposal করবো বড় অবস্থা নাকি কি করবো এটাও যাবো না
Reports were called for, my lord.
yes what is that Mr. Bora?
Lordship, on last occasion on Monday, your lordship was about to dispose of the writ petition. One matter, my learned friend, item number. Lordship, item number. Well-
There is no requirement of records. What record will you want? What records are you posting?
Of the, my lord.
That is already there.
That validity has already expired.
Madam, what more is required? You come to
Humble prayer is that this, your lordship may.
both of them. There was another person
Yes.
who said that his case is being considered for. How can you consider?
That's right.
Both of them will not be considered.
Yes. Fresh selection process. will-
Fresh selection maybe.
That is up to the authorities. That is at page 22 of the second case. Where is the counsel for the second case? You are appearing. Okay.
My lord, I am praying for withdrawal my petition.
You want to withdraw? Writ petition number? Writ petition number?
7315.
7315.
Item 12.
Item 12.
It will not help you in any manner. Because I'll make it clear in the second, in WPC number 138 that the select list has already expired. Okay, withdraw.
Interim.
Heard, Mr.
Chair Rashid on behalf of Eti Sarkar.
No, on behalf will not do. Get Mr. Sarkar. Or we are dismissing both the writ petitions. Get Mr. Sarkar. On business will not do. Yes, madam, what is your case?
My lord, initially the petitioner was appointed as the Anganwadi minor helper, my lord.
This is for promotion.
Yes, my lord, this for promotion to Anganwadi worker, my lord.
Hmm.
She appeared in the interview, my lord.
Anganwadi helper is of 1812. Right?
Yes, my lord.
In 350 number Dokhin Senimari.
Dakshin Senimari, okay, Suburi, Anganwadi Center, my lord. So the interview was held in respect of 5 number of centers, my lord. And in respect of 4 centers, my results were declared, but only the center where for which the petitioner appeared, that, my lord, result was not, my lord, declared, my lord. And in the meantime, my lord, the validity of the, my lord, interview was expired, my lord. One, as per clause 14 of the notification, my lord. Validity of the select list expired.
What is this paragraph 2, madam, you have said? Petitioner begs to state that initially she had been appointed as so-and-so, 1812-2000 issued by so-and-so in 350 Dokhin Senimari Dokhin Pupsuba under Lahorigat. Subsequently, in the year 2003, she was transferred to 312, another center. Okay.
Since then, my lord, she is working there. And during her tenure.
One second. Okay, then what happened?
Then, my lord, she appeared in the interview and she was found eligible, my lord.
So the post Anganwadi center to which you were transferred,
My lord,
therein
Dokhin-
2060 vacancy of Anganwadi worker arose.
Where, my lord, in 2016, the Anganwadi worker of that center, my lord, she
Right.
died.
Advertisement was
2013, my lord. Notification dated 4/3/2013.
no, that is the guidelines.
Yes, my lord, the interview was held on, my lord,
Where is the advertisement in the record?
advertisement I have not annexed, my lord.
24/01/2020. 24/01/2020.
24/01/2020. Advertisement. Okay, selection.
Election was held, that is, an interview was held on 13/2/2020.
Election was published 15/2/2020.
Select list published on 15 to
2020.
20. Approval of the director is on 14/5.
14/5.
And you were recommended. You were recommended. And where were you working?
My lord, this for the
Dakhin Senimari, Dakhin Pop Supuri. Same place, both of you are working.
no, my lord, I am only single.
Then you are also in the same post, madam.
No, my lord. This is Dokkin Senimari, Dokkin Poop Suburi.
You
Anganwadi
come to
Center.
your para 2.
Now this post, my lord.
My lord, at present, at para 3, my lord, I have, my lord, explained, my lord. That at present, the petitioner is working in Dokkin Senimari, Dokkin Poop Suburi. Anganwadi Center 312.
Same one.
As Anganwadi helper, she is working, my lord.
Same one. Who is working where?
My lord, there are only single
I know that.
helper is there. And I am.
Where is the petitioner working? The other case. Where is she working?
My lord, he is working there prior to where he is appointed.
Okay. You both had come on mutual transfer to each other's place. Subsequently, you were again sent back to your respective.
And I am here working for last 5 years, more than 5 years.
When did you come back to this Pup Suburi?
Exact date is I'm not mentioned here.
Okay.
2016.
And why after 14/5 your appointment was not made?
My lord, actually here one case is filed by the present petitioner, that is item number 11.
There is a stay order.
Not stay actually.
Then?
My lord, then the official, I was approached before the official.
No, your letter of approval is of 2020. 14/5/2020. The institution of the item of first case is 2022. By Shamima Yasmin is 22. Before that, you came before this court in 21. Any order passed? Any order in your favor?
No, my lord.
When was this case? 27/12/2021. So you had instituted this case after the lapse of the validity period.
My lord, I was approached before the concerned authority,
But you came before this court after the lapse. So the select list is no longer 1 year. Even if you had come within that 1 year, we would have entertained. say that the select list continues, but here it's not done. So nothing is there. There'll be a fresh selection, both of you appear.
Yes,
Fresh selection, both of you appear. That's all. Right?
yes.
Dispose of. And Namgita, you just give your name. Namgita. That's a part of it. Yes, Mr. Rushil.
Hearing that for the same post, that second advertisement is there. So
What happened?
that should go.
My lord, the matter has become infructuous.
Okay.
My lord, long back on 6/9/22, we have withdrawn the second advertisement.
Second advertisement. Heard the Lanark Council for the, heard Mr. A. Roshik,
I'm
Lanark
just placing
Council
it
for
here,
the
Roshik.
petitioner. What happened to the first advertisement?
My lord, I just showed the information of the second, my lord.
So first, nothing has been done.
Nothing has been done, my lord. And it's now in between 6 years has passed.
Full stop. So, Mr. Roshik, this has been withdrawn. What to do?
That infectious.
It is,
Full stop. Heard Mr. A. Roshik, Lanark Council for the petitioner, and Mr. R. Dhar, Lanark Standing Council. Lanark Council appearing for
my lord, all, my lord.
No, 1 and 2 I am agreeing.
1 and 2.
My lord, I am appearing as a government councilman.
A government advocate for respondent number 3 and 4.
Right.
He for respondent number 1 and 2. Full stop. The petitioner in the present proceeding has presented a challenge to an advertisement dated 11/2/2022 issued for the post of, for recruitment to the post of Gaambura, charge number 7, under the circle officer Senga, Borpeta. Also, it is the contention of the petitioner that for the same very post, an advertisement was so issued earlier on 1/6/2018. Mr. Rashid?
My lord.
1/6/2018, and the process of recruitment in pursuance thereof was pending, and accordingly, the respondent authorities could not have issued a fresh advertisement again on an advertisement again on 11/2/2022 for the post which was already put to recruitment by the earlier advertisement dated 1/6/2018. Today, Mr. Dhar, on instructions received from the Office of the District Commissioner Borpeta, from the Office of the District Commissioner Borpeta, has submitted that wide a notification dated 21/2/2022. No, by the notification dated 6/9/2022, by the notice dated 6/9/2022, the advertisement dated 11/2/2022 was cancelled. So, in view of the above development taking place in the matter, no further live issue arises for consideration in the present proceedings, and accordingly, the present proceedings stand closed. A copy of the communication dated 26/11/2024 furnished by Mr. Dhar is kept on record and marked as X.
Interim order or password, I think.
Interim order passed earlier shall stand vacated.
If I pray that this matter may kindly be taken up at two lordship. I'm on behalf of Mr. Ayat Sekia. He's arguing a matter before the revenue authority lordship.
Okay.
May I please, your lordship?
Hmm.
Lord, the petitioner before lordship was a chairman of sub-divisional SC Development Board, Dhubri, my lord.
That's why I asked you, what is your right?
Is there a doctrine of pleasure, my lord?
Hmm.
Appointment.
As per instruction, the earlier term is over, my lord.
Withdraw it. Don't invite me to make a comment. What is your name?
A. Rashid.
A. Rashid, you are in the case.
Yes, ma'am.
Item number Kimanitul? 17.
15.
15. Yeah, Rashid. Rashid, Lanark Council for the petitioner submits that the term, initial term of engagement of the petitioner herein as the
Chairman of the.
chairman of
SC
the Subdivisional SC Development Board, Dhubri, is already over, and accordingly, he submits that he be permitted to withdraw the present writ petition. Post of prayer accepted. Post of prayer is not objected to by Mr. R. Dhor, Learned Counsel for the respondents. Post of prayer accepted. Writ petition stands dismissed on withdrawal.
This is for lordship's family pension.
What happened, Mr.?
My lord, I have received a communication from the
Hmm.
government, my lord.
Hmm.
My lord, that little back earlier, my lord, I was referring to, my lord.
Hmm.
My lord, the executive engineer doesn't have authority, my lord, to
That's so.
regularize. And my lord, the government could not find, my lord, any such approval or anything. No iota even.
Mr. R. Dhor, Learned Standing Counsel, PWD, has placed before this court an instruction received by him on 26/11/2024, wherein it has been highlighted that the regularization of the services of the husband of the petitioner was not so done with the approval of the governmental authorities, and accordingly, they said approval would be of no consequence and would be of no consequence. Full stop. Accordingly, it is submitted that the petitioner herein would not be entitled to receive family pension. Full stop. Mr. Dhor is now Mr. Dhor is now required. Is now the respondents in the PWD department are directed to file an affidavit in the matter, incorporating the such stand so as to enable the petitioner to counter the same. Full stop. Registry to list this matter again after 4 weeks. Mr. S.K. Medi, Learned Standing Counsel, AG, is present. A copy of the communication dated so and so is kept on record and marked as X. X बोले लिखित हुई report.
Lordship, issue before your lordship, lordship petitioner's pension has been kept withheld, lordship.
You are getting your provisional pension now.
Lordship.
Provisional pension is
After
getting.
the court order, interim order, lordship. And
otherwise,
after the court order, lordship, they have recovered my arms and ammunition and it was handed over to the.
Arms and ammunition have been recovered.
Recovered.
Your lordship, I have received the paragraphs yesterday. Let me just file a detailed affidavit in.
No, only question here is because the arms and ammunition which was issued to him was missing. From where it was recovered?
It was recovered from Tezpur, lordship, Sunitpur district.
From the persons who had taken it away.
And we have deposited it to the Kukurajar, lordship, after receiving it. And they have released me that leave encashment, GPF and RR. But no more pension has not been regularized and DCRG has been kept withheld.
Mr. Bora, just that much only. Man is waiting.
Otherwise, in this particular, if I may just read out from the paragraph comment. Lordship, with regards to paragraph number 21, what he has written, it is not a fact that retired Dilip Kumar Nath has drawn 5,72,860 as leave salary, rupees 3 lakhs.
I'm not on that, whether the arms and ammunition has been recovered or not.
And with regards to arms and ammunition, I'm coming step by step, your lordship. Now, as rupees 4,70,000 as final GPF and as per order dated 30/9/22, the sanction was accorded for payment of provisional pension to till the final PPO issued by AG. Now, with regards to arms and ammunition, your lordship, herein, it is a fact the petitioner reported at the Tezpur police station on 16/12/2021 itself, and he was given Jimma of below mentioned arms and ammunition on the same day. 1 Insas rifle bearing butt body number so and so, 3 number of empty transparent Insas magazine, 60 rounds live ammunition. However, the petitioner was not given the rest of the arms and ammunition, that is 2 magazine and 40 round of ammunition.
That he was not given at the initial stage.
That he was not given.
Then what was the recovery from him pending?
After that, it is not clear in this particular. Then I have to get the instructions.
Mr. D. Bora, Learned Counsel, appearing for the respondents, shall receive specific instructions as to whether the arms required to be recovered from the petitioner, of arms issued to the petitioner during his service tenure have been redeposited by him and or recovered by the departmental authorities from any other source. The above instruction shall be received by Mr. Bora in writing from the competent authority and placed before this court on the next date of listing. Full stop. Registry to list this matters again on 18/12/2024.
As per my instruction, it was deposited on 28/11/23, Lordship. It was received, Lordship.
Because see, you give me that there, tomorrow
Yes,
they
yes,
may,
they
there are
will have
many
to-
things left.
They will have to get.
Let them place, that will be the final.
Another instruction they may to require at that time whether charge sheet has been filed or not, because no judicial.
That is different. That's for them to do.
The petitioner was dismissed from service, my lord. And, my lord, my ground only, my lord, that before inquiry report was not furnished to him and no so cause was issued to him before imposing, my lord, penalty.
Your conduct does not, your conduct
My lord.
does not inspire confidence.
Well, that is true, my lord, that.
2003,
Yes,
you were 13, you were 3, you were missing.
my lord.
After 10 years, they instituted proceedings. First show cause received by you. You did not respond. Second show cause, the inquiry officer repeated communication. You did not respond. It is a fact, there is a doubt whether the inquiry report was given to you or not. There is a doubt. There is a doubt.
They have admitted, my lord.
Fine, I say a doubt, let's say. Now, you are a disciplined force officer, right? Now, after the imposition 10 years, why should we entertain this petition? Where is the ground for delay?
My lord, delay paragraph 14.
14.
Paragraph 14 I have stated, and
Okay.
they have not objected it, my
Oh,
lord.
forget it. They did not object it. It's for me to satisfy.
My lord.
Yes. You are out from service from 2003.
Hi.
Charges 2003 onwards unauthorized. So 2003 onwards, you are not there. So what made you awake to consult an advocate in 2022? What did you do in? Let's forget you know nothing about the proceedings.
My lord, he was suffering from some mental illness.
Where is that material?
Well, because, my lord.
Where is that
lots of
material?
knows, my lord, the person is from Rava community and lots of from the Gwalpara area. Lots
Where
of
is
knows, my
that
lord,
material to show that he was suffering from mental ailment?
Nothing, my lord.
Then
Because, my lord,
that is only a plea.
my lord, Ayurvedic and other treatment was
That
there.
we cannot, there has to be some material, some document to justify. Your wife was there, your wife was receiving communications. Why the wife had not taken up the matter with the authorities?
Yes, my lord, that is true, my lord, but illiterate person, my lord, the wife is illiterate and he was suffering from mental illness, my lord.
We
Even
can't
then,
lay
my
down
lord,
a law.
even
It will
then,
be a
my lord,
very dangerous proposition if we lay
even
down
then,
that.
Even then, my lord.
If we hold like that, it will be a dangerous proposition.
But even then, if, my lord, major punishment is issued, my lord, the inquiry report along with the so cause report, so that he can defend, my lord.
I'm sorry. Yeah, but disillusion was abandonment of service. Food was on.
I agree, my lord. SARS inquiry report, procedure expertise, SARS are.
No, we will not entertain Mr. Kulta. Sorry. What do you say, Mr. Bora?
Lordship, I totally agree with you, whatever has fallen from your lordship. Because we have actually given him notice, but he decided not to appear. Obviously, it will become,
Abandonment of service.
obviously it will become ex parte, your lordship.
Until 22,
There's no explanation as such.
nothing. This para 14 is neither here nor there.
Lordship will consider only that violation of natural justice point.
While not. While violation of natural justice cannot be considered in isolation. It have to take the whole facts into place. You were, see, you are a government servant. In addition to that, a member of a disciplined force. You can't stay away on your own wish. And one fine morning you feel, okay, I'm going back. You come. Is that the law?
That is true, my lord. I appreciate, my
We'll
lord.
not go by
That's true.
technicalities in such. I'm sorry. This court is not going. Go on appeal.
That is true, my lord. I appreciate. But the thing is that, my lord, only that aspect lordship will consider. He may be a bad person, my lord.
He is a bad person. He has been punished. Some technical error, we are condoning that.
And that is, my
We are
lord,
condoning that.
that is serious, my lord.
No. In the facts, it is not serious. I'll give my reasons. Shall we proceed? Or you want some? Shall I proceed to close the matter, or you want to have a better chance? Take a chance.
Let me take a chance, my lord.
On the prayer of Mr. N. Kolita, learned N.K. Kolita, learned counsel for the petitioner, raised it to list this matters after 8 weeks on a date to be fixed by it. But if it comes back to me again, I'm dismissing it. I've already dismissed one matter. Same situation. But casual nature of petitions we can't accept.
In this case, my lord, on the last occasion.
Yes, what is your?
But
My lord, here in this matter, my friend Dinath is appearing. We have received the record and my lord terabyte document dated 26, my lord. This morning it has come.
Why it is required?
My lord, we need 1 week
You
time.
have 11C. Let us give it that in addition to the headquarters staff, even the field staff are entitled. Still, why is this case not being considered? He's the senior most there.
My lord, we have our reasons, my lord. Let
He's
us,
not direct for his promotion, but at least his case should be considered.
my lord, let us file affidavit. Or else my lord will just record this. The government council prays for 1 week time to file affidavit, my lord.
Why? Why was the affidavit not filed? And the records were directed to be produced.
Record has come, my lord.
Then show me that. Show me the fact as to why the case of the petitioner is not being considered. His fundamental rights are being violated.
My lord, we need only 1 week time. My lord will fix it next week.
You tell me the reason. That is what exactly the court required you on 11/11.
My lord, my friend Dinath is handling this matter, my lord.
Call Mr. Dinath, we'll interact with him. And you take a stand before this court that the persons in the field are not entitled to promotion. You file review, you file a writ appeal. What happened to that writ appeal? Second appeal, sorry, I don't know what the second appeal is. The word used is second appeal. What happened to that second appeal after the review?
My lord, I am not aware of the fact.
they
My
have
lord.
not filed, my lord.
They have not filed any appeal.
After the petition, the review petition was filed.
That is also
That-
dismissed.
gone. They have not filed.
And that has got nothing to do with you.
In fact, in the review petition, they have taken the stand that they have to, the appointment has to be made as per the rules.
11(1)(c). Okay, let's say this court has given that order.
And in fact, we have filed an additional affidavit wherein that person has been
Have been promoted subsequently.
Yeah.
On the prayer of Mr. Ardhar, learned counsel for the petitioner, who submits that the instructions as well as records of the matter has been received by him, and the affidavit in the matter would be filed invariably on or before which date?
My lord. Today is 27th.
26.
Today is 27th.
27, oh, sorry.
My lord will fix on 4th. By 4th we will file, my lord.
No. Shall file the affidavit on or before 4/12/2024.
Madam.
Also, register to list this matter again on 9/12/2024.
Madam.
For final consideration.
Right.
9/12/2020.
My lord,
Full
deep-
stop.
deeply.
Mr. S. Hunt has expressed urgency in the matter. Accordingly, it is provided that in the event the affidavit is not so filed by the respondent authorities on 4/12/2024, this court would proceed to dispose of the present writ petition. To consider the issue arising in the present writ petition by basing on the materials already available on record.
my lord, deeply blessed.
It's not hard. It's just buying time. Nothing is there. Your own stand. How can you go?
My lord.
Here, please, Lordship. Lordship, here the petitioner got his promotion, Lordship. And we are not pressing this petition.
What, okay, we will not go into, what is your qualification of your petition? He's a graduate. You have said everything everywhere, but only the qualification has not been disclosed. Yes, Mr. Bora, what is his qualification?
My lord, we have not received instruction and it is not there in the petition also, my lord.
Okay.
Probably he is graduate, otherwise he would have been considered, my lord.
Miss
I may be.
R. Mehdi, Learned Counsel for the petitioner submits that the relief sought for by the petitioner in the present proceeding has already been received by him from the respondent authorities, and accordingly, the present petition has become infructuous. Also, in view of the above prayer is not disputed by Mr. Bora, Learned Counsel appearing for the Health Department. Also, in view of the above, the petition stands dismissed as having become infructuous.
Here in this matter, yesterday we have filed affidavit on behalf of the respondent number 5,
Who is respondent number 5?
the chief executive officer of the
Okay.
municipal board.
What is your stand there?
And therein we have stated that he have paid whatever is necessary to the petitioner and somewhat we have denied whatever he is
Okay,
claiming.
Mr.
It's a.
D. Bora, Learned Counsel for the Learned Government Advocate appearing for the respondent number 5 has submitted that an affidavit on behalf of the said authority has been filed yesterday. You have received a copy.
Yes.
Oh, sir, want to file a reply to that? The petitioner, Learned Counsel for the petitioner submits that he be given 2 weeks time to 3 weeks time to file a rejoinder thereto. Full stop. Prayer accepted, registered to list this matters after 3 weeks. on a
Appeal in
date-
opposition both to the writ petition as well as the additional affidavit filed by the petitioner.
Okay, fine, whatever it is, huh?
So I am appearing on behalf of respondent number 4.
Who is respondent number 4?
The chairman municipal board.
Municipal.
Mr.
B. Dekar.
B. Deca appears, is present for the respondent number. You file your affidavit.
Lordship, in the first title, it is respondent number 3. I have instruction to appear on behalf of him also. But this chairman town committee, it has been converted to municipal board. So I could not file a occurrence on behalf of the respondent number 3. Lordship.
Initially, it was a town committee letter. It has been converted to.
Letter.
It is submitted at the bar that the earlier Howley Town Committee, earlier Howley Town, at the time of, it is submitted that the Howley Town Committee has now been renamed as the Howley Town Corporation.
Municipal board.
Municipal Board. Full stop. The above renaming having occasion during the pendency of the present proceedings, the petitioner is permitted to bring on record an amended cost title incorporating the present status of the respondent authorities. So such amended cost title be filed within a period of 3 weeks, within a period of weeks from today. You bring it on record.
Yes.
Obliged.
None appears for the petitioner on call. Registry to list.
The matter can be taken up at 2 years.
No, we have many matters at 2.
I'm on behalf of Mr. Ayed Sheikh, Your Lordship. He is appearing before the revenue appeal board.
He'll be here in the second half.
Registry to list this matter again, as prayed for by the Learned Council for the parties, registry to list this matter again after 2 weeks on a date to be fixed by.
Well, no, AG has no role in this case. We have no role in this case. AG.
Be there, we can see you. Yes, why no affidavit is filed?
That pension and other related issues will be handled by the Department of Secondary Education, Lordship. I'm told that the DO. So perhaps the Department of Secondary Education, my learned friend is there.
Filing affidavit. Yes, Mane, for my asking or you want to file?
I wanted
Oh,
to
you-
find your lordship because
Okay.
I need
Heard
to
Miss
take
Pidas,
instruction
Lanet.
also.
Learned P Das, Learned Council appearing for Learned Standing Council Secondary Education Department, who submits that she be given 4 weeks' time to file her reply in the matter. Also, it is to be noted that the matter involved in the present proceedings pertains to the pension and pensionary benefits receivable by the petitioner herein on account, family pension and pension receivable on account of her services or her services of.
No, Lordship.
Father's service,
Our
mother
father's
has died,
service.
mother also died, Lordship. It was returned by the
Pension
authority.
and pension benefits, and accordingly it is expected that before the next date of listing, the authorities in the secondary education department and as well as the other respondents shall invariably bring on record their respective stance by way of filing affidavits.
Well, our limited report is on our court, my lord. Although we have filed RTA application before the authority, my lord, no information has been supplied, my lord, to the petitioner, my lord. And therefore, my lord, he could not file an appropriate petition before the court, my lord.
31 to 3, boy.
31.
But you have not, that is not your prayer.
Item 31, my
If you
lord.
have filed an RTA application, they are not, you go upon appeal, there is a provision there.
My lord.
File an appeal.
It's 31.
This is, what is your name of your case?
Item 31, my lord.
Kobita Bora.
I'm sorry, my lord. My item is 31.
That is why I said, Mr. Pijaswige is appearing for Ms. D. Buragoin, 31.
Yes, my lord.
None appears for the petitioner on call. However, Mr. Bora, Learned Council, Standing Council, Health Department is present. For the ends of justice, registry to discuss matters again after 6 weeks on a date to be fixed by.
Obliged, my lord.
Yes,
Now it is approved.
my lord. I'm sorry. Page 20, my lord, the legal notice, my lord, served upon the respondent.
No, that is not the way. You have to go in terms of the act itself. If the first appellate, if the RTA authority,
My lord.
state PIO is not giving it, go
The-
upon appeal.
Page 23 itself, my lord, appeal, amounts to an appeal, my lord.
There is a format. What is the information you want?
My lord, page 20, my lord, the information, my lord, that have been sought from you.
Your Honor, the matter may be adjourned for the day as my senior has gone to appear seminar. My senior is not able to come today. He has gone
Who is
to
your senior?
B Deka. Mr. B Deka. He has gone to a seminar on behalf of CGC.
Engagement of the petitioner as detailed under the service has provided. No, under notification has provided services. Page 20.
Yes, my lord.
You were appointed
My lord,
at one point, then you were
Right.
discharged.
my lord, without any reason. Under what circumstances my service was discontinued, my lord? Nothing has been in.
On the prayer made on behalf of Mr. B. Deka, learned CGC appearing for the respondents. CGC,
Yes, sir.
appearing for the respondents, registry to discuss matters again on, list this matter again on 6/12/2024. On the next date of listing, the learned counsel for the respondent shall apprise this court as to why the information sought for by the petitioner under the provisions of the RT Act 2005 was not furnished to him. If that instruction does not come, your person who has to give, he will act.
Okay.
So ensure that the instruction comes.
Okay.
All right.
Please, Your Lordship, sorry, 31, that non-appearance.
31, ये आता था 31 to be listened. Huh? लिखी दिया Miss D. Buragoy, learned counsel for the petitioners, and Mr. D. Etu Bora. Health matter.
Health, affidavit has not been filed, they were.
4 weeks time.
Yes.
So as prayed for by Mr. Bora, further 4 weeks time is granted for bringing on record the stand of the departmental authorities by way of filing an affidavit.
Objection.
So how you are appearing?
Yes, Milord.
Yes, where is your affidavit?
My lord, I don't think so. We will need affidavit, my lord. I have an instruction, my lord. The matter has become instructless. We have, my lord, we revoked the order, reinstated him. We have written, the DGP officer written to the commandant to act on his pension, my lord. Everything given.
Yes,
Milord,
you have this information, 13/11/2024. Order has been withdrawn.
yes,
Then you have that information.
perhaps he has got, Milord, but that my pensionary benefits.
Well, now they'll give you, everything has been done. So-and-so has requested commandant so-and-so to process the pension proposals as per existing rules.
But till this day, I haven't got anything.
Arey, this was issued only on 13/11. It may not have reached the commandant also.
Then Milord, keep this petition,
Why?
keep this petition pending,
Why?
Milord.
Why?
My lord will find that appeal order, my lord, which is annex there, my lord. It's very crystal, my lord. We have taken.
When is your original date of retirement?
Milord,
Original rate of retirement?
Milord, I can say exactly because date of.
You don't know anything.
Appointment is not there, Milord.
Ah.
That is problem. Because this all mother is doing all these things.
Huh?
The petition is filed by her, his old mother. Milord.
Why?
He is no more, Milord.
Petitioner, that my
Petitioner
lord,
is no
the
more.
original person is deceased, my lord.
Petition is no more.
No more. Prior to this, he was removed from the service, Milord.
If my lord goes through the order, my lord will find that we have taken a, my lord, a very humanitarian ground, my lord. There was no principle of natural justice. We have, my lord, already said it in the order, my lord.
No.
We revoke everything.
The penalty was imposed thereafter the man died,
Yes,
right?
yes.
After the appellate order or before the appellate order?
Before the appellate order.
Before the appellate order. That was pending, my lord.
The deceased himself filed the appeal, but he could not get the result.
Also, Mr. Thor, learned counsel for the respondents, on instructions have submitted that the removal order passed in respect of the son of the petitioner hearing has been revoked by the appellate authority vide an order dated 17/10/2019. Also, it is also contended that the pension and family pension proposal in respect of the petitioner hearing has been directed to be so prepared by the commandant of Commandant, 22 APBN. APBN to Horungu. Likabali Dhemaji. Also, accordingly, he submits that the pension and pensionary benefits receivable by the petitioner herein on account of the services rendered by her son would be so finalized within a period of 4 weeks,
My lord,
4
make it
weeks.
6 weeks, my lord.
6 weeks. Full stop. Raised to list this matter again on 6 weeks sufficient date for you. On the next date of listing, the respondents, more particularly, respondents shall place before this court the PPO issued in favor of the petitioner herein.
My lord, then, my lord, PPO, my lord, we don't issue, my lord. It
Okay,
is the AG, my lord.
we'll place before this court the
Proposal, my lord, that we have sent.
the documents reflecting the submission of the proposal in respect of the pension, family pension proposal in respect of the petitioner herein before to the Accountant General Assam, to the office of the Accountant General Assam.
That we can do, my lord.
A copy of the communication dated 13/11/2024 as furnished by Mr. Dhor, Ardhor, is kept on record and marked as X.
A copy be served upon me, my lord, by him.
My lord, that is the internal communication, my lord. That I cannot, my lord.
You will get it. We have noted it. What is the? Give him a copy of the appellate order.
That I can.
Appellate order. Give.
I please, your lordship. My
So,
lord,
Chaudhary, why are you waiting for? What are you, which item?
Item 53 of supplementary.
Okay. It's always a pleasure to see you in the court. Who is opposing you here?
PWD,
Comment.
my lord. It is a very short matter, my lord. Only, my lord, I have already been retired. Only, my lord, the pay protection for getting pensionary benefit. No salary, nothing else. We do not want anything.
Scientific assistant.
Yes. Yes, my lord. Initially, I was appointed in 1981 as workshop field assistant. Thereafter, 1986 as workshop surveyor. Then
19
certificate assistant in 1990.
First is 1981, work
Yes.
charge, field assistant.
Field assistant.
Then 1986,
86.
earlier to that.
Yes,
You were work charge surveyor.
surveyor. Therefore, my lord, 1990
1990
as field assistant, sorry, scientific assistant as sanction against.
This
Yes,
is regular
yes,
appointment.
Regular. I retired, my lord, on 30 March 1990.
33, 2000.
31 3 1990, 1919.
What is their stand?
Their stand, my lord, I am not entitled for getting regulation there. I do not want any regulation virtually. Your lordship is very much aware. It is a question of, is a on the end, my lord.
Your case is that as a work charge employee, I was entitled to a scale of pay.
Yes, and I got the same.
You got it. And now when you were appointed as SA, it was a higher scale of pay.
Highest.
But the fixation benefits were not given to you.
The fixation of salary is there. Only when pay protection has not been given. Now, my lord. For pension.
Why? If the fixation has been made, where is the question of?
That is the thing, my lord.
Yes, Mr. What I didn't understand. You are the man finance.
If fixation, pay protection has not been given, then it's a fresh appointment. Only issue is how.
If you have fixed his pay by considering the work charge period, that is enough. That means it
Is the stand of the petitioner.
petitioner. Yes, Mr. Dhor, what is your?
My lord will take up my affidavit, my lord, page number 57, running page. There are 3.
Para?
3, my lord.
That your department submits that government has been taking steps for relaxation of Rule 3.
No, my lord, that is not my affidavit, my lord.
Sheikh Mukta, sorry.
That is a affidavit filed by respondent number, my lord, 1.
Respondent number 1. $73. The answering said that Tapan Kolita had served as so and so. That is one.
Yes, my lord, that is the one.
Retired so and so.
Has served as work church field assistant from 12 to 81 to 86.
So and so.
Served work church surveyor from 86 to the date of joining as regular scientific assistant on 9/10/90. However, the period of work church service was not regularized. That period was not regularized, my lord.
Why should you regularize that period?
Yes.
How can a work charge period be regularized? It will automatically attach to that. Sangeeta Roy. However, the period of work charge was done by appointing authority which requires approval of the period accompanied or retired. He got a regular appointment.
That, my lord, the moment he gets a regular appointment, my lord, that will be considered as new appointment, my lord.
Fine. But if there was a service as a work charge employee,
My lord.
and where is the fixation of pay on his appointment? Where is this appointment letter? Mr. Mukta, have you brought the initial fixation of pay on record?
Appointment letter is there, my lord.
In this connection?
Page 27, my lord.
27.
Initial appointment as scientific assistant, my lord.
26. The so and so is hereby appointed work charge surveyor. Working under is hereby appointed so and so. Mention post so and so, so and so.
You will page 32, my lord, they have mentioned the pay protection has been granted, my lord. Page 33, please clearly
Page
state, my lord.
32.
32, my lord. Lecture I.
But they said work charge period has been, whereas as pay protection from the date of so and so.
Granted.
Mr. Dhar,
My lord.
he was drawing at a particular stage in the as a work charge,
My lord.
a work charge field assistant, right?
My lord.
You appoint him as scientific assistant.
My lord.
In the order, you recognize that he is a work charge field assistant, right?
My lord.
Now, while making that appointment, he was not given the initial scale of pay. He was given the scale of pay which came from the post fixation on account of pay protection of the pay he was drawing as a work charge field assistant. Survey. And if that be so, pay protection was given, the period 31, it automatically comes in the work charge period. So that period will also add up to his service. And he will be. Now, what is the problem? Where is the problem?
The problem, my lord, they are saying
Problem is, my lord, page 32 of the red petition.
regular pension has not been given, my lord. Only provisional pension I am getting. Only thing, my lord.
Page number.
But they said work charge period has not been regularized.
Regularized.
Regularize it under 31. Regularize it under 31. Because Mr. Dhar, you
My
look
lord,
it at this manner.
My lord.
Say the petitioner continued as a work charge employee.
My lord.
Under the 2005, that scheme,
My lord.
he was regularized. Right? Then what happens in terms of your decision? The entire period minus 6 years, work charge period minus 6 years, gets added to his qualifying service. Sanjita Roy comes, 6 years thing taken away. So the entire period is. Now, why is that? When you have given him pay protection, why are you not doing that here?
My lord, already we have declined, my lord, that we cannot regularize, my lord. We in
Then
para
we'll have to come in.
para 4, my lord, we have stated, my lord.
Of your affidavit.
Yes, my lord.
Para?
Para 4, my lord.
You have filed any affidavit, Mr.
we try to relax, my lord. We short, my lord, from finance to relax that rule 31. But my lord, finance declined, my lord. That is
Why?
what we said.
Why, Mr.? Why?
Basically, lordship, here, so far as one report is there, lordship, by the PWD. That it is, he has been granted pay protection. For granting pay protection, lordship, regularization of the earlier period, what's the period?
That is the how, Mr. That is what I don't understand. How can you regularize the work charge period? You can only add it by using 31.
One can claim pay protection only on the basis of regular service. On the basis of.
This is not what has happened here. What has happened is he was working in a work charge establishment. There was a particular scale of pay attached.
Workers always carry this thing.
So when he joined against a regular post, he was, say, 900, 1200. He was already drawing, say, 1000. So his pay was fixed in the regular scale of pay as an SA, say 1050 or 1100. So that is what they meant by pay protection. That is a different concept altogether. Now, whether the period of work charge, that period, work charge period, that will be added or not. That's the only question. Now, for that, his whole pension is now.
His pay has been fixed on the basis of the scale he was getting as a worker.
Maybe. That is already there.
Lots of workers not in a regular establishment.
Fine, no need, use 31. Sangeeta Roy, qualifying service. Qualifying service only. As qualifying service only, you have to take that. Have your instructions. Only that these words, regularization and all are misnomers. Mr. Chaudhary, am I correct in saying that only that period has to be taken as qualifying service? That's all.
Not only that, only my lord, only pay protection, not, I'm not.
No,
paying
pay
for any
protection is
salary.
already given.
Yes,
Then
I'm not paying for any salary, any money.
no need.
Only
You
pay
not-
protection
Only that
for
period.
getting pensionary benefit.
Sir, I can understand their, because they say that the period, that the service of work charge was not a regular service.
Yeah.
So there was no question of any
Pay protection.
pay protection. Be that as it may, long back, you were given that. Now that period of work charge has to be regularized. Period of work charge cannot be regularized. It can be counted as
Yes.
qualifying.
As your.
Only that much they'll have to do.
Yes.
When? You have your instruction. No, before vacations.
My lord, in 2 weeks, vacation is,
Vacation will not come. Okay.
it's not come. Is it?
Mr. Chaudhary, when will it be convenient for you?
As your.
We can have it on 16th. Or let us have it on 17th, Tuesday.
On Thursday.
Tuesday. Or you have something on problem on Tuesday? No, if you have problem, we can put it on Wednesday. No. Mister, you have enough time. 1 minute only for you. 17th. But Mr. K. Chaudhary, learned senior counsel, assisted by Mr. S. Mukhtar, learned counsel appearing for the petitioner. Also heard Mr. R. Dhar and Mr. P. Naik, learned counsels appearing for the respective respondents. The case of the petitioner is that on account of issue arising with regard to the manner in which he was accommodated as against a regular post of scientific assistant, a scientific assistant, comma, by reckoning the pay drawn by him as a work charge field assistant, comma, the final pension of the pension and pension benefits of the petitioner are not being finalized, and he is being extended only with a provisional pension. Also, Mr. Naik and as well as Mr. Dhar submits that they be permitted to receive their instructions in the matter as to why the period of service rendered by the petitioner on work charge basis shall not be treated as a qualifying service to the service, regularized service already put in by the petitioner as a scientific assistant. The above instructions be placed, received and placed before this court on the next date of listing. Also, registered to list this matter again on 17/12/2024 for 17/12/2024.
Lordship, respond number 3. I'm for respond number 3.
AG,
AG.
any instruction?
Yes, Lordship, there is instruction.
They are relying only PWD standard, nothing else.
Ask your officers to also apprise us, how can a work charge period be regularized?
If we keep part of my law.
No.
My,
Yeah, it will come.
only thing, my lord, it is listing so many.
No. It will come. Don't worry, Mr. Chaudhary, we are there.
Yes.
Work charge period cannot be regularized. A person will be regularized comparing that work charge. Work charge period will remain like that only. It will be added as a qualifying service.
That's it.
As you know.
Please, your lordship. My lord, the petitioner husband had rendered my lord 39 years of service under.
That same thing.
My lord, same, my lord.
Where is that order?
My lord, you can see.
I think recently we had passed some order.
Yes, your lordship.
Fazlal Rabi. Same thing.
But item 44 also same, my lord.
44 also same, my lord. In Fosilla case, my lord, para 26. Page number 9.
This is by the person concerned or the
Wife, my lord.
My lord, wife, my lord.
wife.
And my,
So Samirun Nisa would cover.
my lord.
What is the issue?
Issue, my lord.
They have filed an affidavit.
My lord, can
This
you?
is the first time you are coming up before this court?
No, my lord.
After motion.
No. Earlier.
No,
any
my lord, no,
repetition
first
was
time,
first-
fresh, my lord. My lord, page 60. my
Service
lord,
is from which period to which period?
My lord, page 62, from my lord 28/4/1961 to 30/4/2000.
28.
28/4/1961 to 30/4/2000. Total length of service 39 years, 2 days.
And how much have they taken?
My lord, they have deducted my lord 14 years, 1 month, 7 days, and calculated my lord 24 years, 11 month and 0 days, 11 months.
24 years?
24 years, 11 month and 11 month, counted for pension. And deducted
Qualified.
14 years,
Disposed of.
my lord. Item 44 is the similar, my lord.
44, what has happened?
44, my lord.
This
similar.
is, he's the person concerned himself.
Yes, my lord. PPO, my lord, page 81. Operating part, page 82. The calculation part, my lord.
Itu minor nahi hai. 34. Hold on. Take it as a rule.
Procedural law directly, my lord.
Hmm?
Procedural law judgment is similar, my lord.
My lord, Justice Roy's judgment.
My lord. My lord,
Gross
page,
service 40 years, 4 months.
my lord,
Non-qualifying 18.
my lord,
Qualifying 20. This much only.
my lord.
Anything
Appointed on 1/5/1957 to 39/1997. Total length of service 40 years, 4 months, 29 days. Deducted
done.
18 years. My lord.
Disposed of.
Highly obliged, your lordship.
Highly obliged.
None guitar not just write down who is appearing in the court cases. Mr. Islam, just give me a note of the names of the advocates.
35, your lordships. The director had written to the CDPO as to on what basis the services of the petitioners were actually released. And he was directed to submit a report way back in May 2024. Thereafter, again on 26th of September, again the director wrote to the CDPO to furnish the report with regards to, he has only submitted report with regards to four petitioners out of the 16 petitioners. The rest of the 12 petitioners reports are still awaited from the CDPO Lakhimpur. Your lordship, some time may be granted directing the CDPO.
What is it? Your CDPO is not even listening to your director.
That's what
Huh?
your lordship. Because like, director is asking on what basis, was there any government order or any direction from this directors regarding retirement age of Anganwadi worker or Anganwadi helper during the period 2005 to 2017, when those petitioners were released from service by their then CDPO Dhokwakhana, ICDS.
Mr. D. Bora. Mr. We'll give him some time. Mr. D. Bora, learned counsel, a learned government advocate appearing for the respondents submits that in spite of repeated directions issued by the Director Social Welfare Department requiring the Child Development Project Officer,
Dhokwakhana, ICDS.
ICDS, Dhokwakhana,
Lakhimpur,
ICDS, Dhokwakhana, ICDS project.
ICDS.
Dhokwakhana, I am Dhokwakhana, to furnish reports with regard to the grounds existing towards releasing the petitioners from service, right?
Yes, Your Lordship.
The CDPO, Dhokwakhana, has not submitted the reports in respect of all the petitioners. Full stop. In the above view of the matter, Mr. Bora shall directly communicate with the Child Development Project Officer Dhokwakhana and receive the instructions so required, which shall be placed before this court on the next date of listing. In the event the instructions are not forthcoming, orders as may be called for in the matter shall be so passed by the court on the next date of listing.
Next date,
List after 4 weeks. 4 weeks.
after vacation, immediately.
May date be kindly given, my
List this as prayed for by the parties, list this matter again on 4 weeks of date. Thought we should do 4 weeks, man, working 4 weeks.
Vacation.
Then wait, you.
Done.
6 1.
Much apply.
Here in this matter, we have received the instructions. Your Lordship, as per the instructions, the petitioners, the name of the respondent number 9, that is the first wife, shows it reflects in all the service records, and that's why we have paid the family pension and everything in favor of the petition, respondent number 9. And in fact, as per the PPO record, respondent number 9 is receiving the family pension of this 39,000 effective from 21 to 2030. They have to enhance pension from 19,000 so and so. So basically, the service records reflect the name of only the respondent number 9.
She is alive.
He's alive.
Any children?
My learned counsel is on medical store. Can you come after 2?
On the prayer of the learned counsel for the petitioner, raised it to list this matter after 8 weeks on a date to be fixed by. Young counsel, you get a brief, read it. We are here. We come prepared. If these are the things you done, we lose our interest. Why? Just assess this code. We are there to see if there is any difficulty. Young counsel comes, I never dismiss. Allow it. Try to do the matter. You are here to do cases or just take adjournments. Read a brief. Whenever you get a brief, take it from me, read it. Right? Come to the court, address the court. And the court will like youngsters addressing the court. Right? We'll help you. But please don't have this adjournment. Come, be bold, argue. If it is to be dismissed, I assure you that I'll dismiss only when your senior is here, not before you. I know. Visit tonight.
Reinstate in service. Departmental proceedings was closed based on an inquiry report. Now I am here at page 10 is the prayer to regularize my period of pension and my.
No orders were passed along with the order passed in the department proceeding?
Order at page 25, Lordship, kindly.
26.
26 and 25.
25, Lordship, last paragraph, the pays and allowances for the period under suspension is to be finalized after completion of departmental proceedings. Page 26 is the closure. Last paragraph. After careful examination of
Mr.
all
Dhor,
My lord. I understand, my lord. Let us file the affidavit, my lord, it will help you.
what affidavit is required here? You have closed the proceeding. You say now because the criminal.
My
proceeding.
lord, only because that 31/5/2022, rightly or wrongly, my lord, authority has passed another order, my lord.
What?
That my lord, this is the order, my lord, I'm replacing. So, my lord, once I bring this on record, my lord, it will be.
Need not be because that subsequent order is on record. This is the, but thing is, how can you do this? 54B says that immediately you close the proceeding, you will have to pass an order. Now you have closed the proceeding. What happens in the criminal case will happen. Charge sheet has been filed.
No, Lordship, charges to my instruction, charges have not been filed. Lordship, there is not nothing pending in court.
Can't be. FRSR counsel. FRSR.
And I am going to retire on February.
Where is the inquiry report?
Lordship, page 24. Page 24, Lordship. And page 22, Lordship, is a submission of the inquiry report. Thereafter, at page 24 is the findings. May I read the last paragraph?
Nothing is there against you.
Nothing is there. No evidence, no witness, and no complaints against him. Lordship.
Then my lord will interfere with annexure 8 of the writ petition. Unless that's my lord.
You have an FRSR with you?
Sorry.
FRSR. State FRSR. 54B.
Sorry, Lord.
But Mr. BP Boran, counsel for the petitioner, and also heard Mr. R. Leonard, counsel appearing for the respondent number 3. Also, the petitioner in the present proceedings has presented a challenge to an order. Presented a challenge to the inaction on the part of the respondent authorities in regularizing his period of suspension with effect from 16/9/2021 to 30/5/2022 after dropping of the departmental proceedings so instituted against him vide an order dated 16/3/2023. Also, the petitioner herein was the full stop. The facts in brief requisite for adjudication of the issues arising in the present proceedings is noticed as under. Also, the petitioner, on being involved in a criminal case and being placed under detention, the Deputy Commissioner, Nagaon, vide order dated 7/10/2021, proceeded to place the petitioner under suspension with effect from the date of his arrest, that is with effect from 16/9/2021. Also, thereafter, where is your show cause?
So, course, yes, Lordship, I have annexed the
When was the show cause issued to you?
right.
Thereafter, a departmental proceeding came to be instituted against the petitioner hearing.
And lecture 5 is the page number 21. The inquiry officer and presenting officer.
There was no department proceeding drawn up against you.
Lordship, and lecture 5, page 21. Page 21, the inquiry officer and presenting officer was concerned.
No, where is that show cause? Mr. Bora, place those matter.
So called.
Because now otherwise,
The inquiry report also does not mention anything.
have your instructions on the prayer of Mr. B.P. Bora, learned counsel for the petitioner. Registered to list these matters again after a week. On the next date,
Then I'll file my affidavit.
on the next date of listing, Mr. Bora shall apprise this court as to the manner in which the department proceedings were so instituted against him.
My lord, I will take with the instruction, my lord.
Mr. Bora, it seems that there was no inquiry, no proceeding instituted against you. If that be so, make it clear, your period will automatically get regularized, right? But if we say that there was a department proceeding and tomorrow it found that there was no department proceeding, their saying will not do, no? You will have to be, there was no show cause.
But if Lordship fixes on Friday, Lordship, I'll take the instruction.
Friday, I have difficulty because they'll all be leaving next week. Yes, have you, who is the name of the council has been shown? Oh, by slip question, no, itu. Everyone order to know. I'm sorry, this matter was kept by slip. So the name of the standing council, Karbi Anglong, could not be reflected. You're there?
Here, but my lord.
No, Karbi Anglong.
Karbi Anglong has to be, they are the main party.
No, it's a mistake. It's our mistake. Because last time I had directed for the reflecting the name of the Karbi Anglong Standing Council, but problem is that the file remained here. It did not go to the bench. Okay. It is seen. Full stop. While order dated 25/11/2024, this court had directed the registry to list the matter today by reflecting the name of the learned standing council KAAC in the cause title. However, the matter being kept in the court as a and the matter having been listed by slip, the order could not be brought to the notice of the registry. Also, accordingly, registry is directed to list this matter again on (9/12/2024). Also, by reflecting the name of the learned standing council KAAC in the cause list.
Get it be on 11th.
11th, no problem. 11th. Yes, Ms. Bora, what is it?
This owner was enrolled in service. on
No, you tell me the law. Facts we have seen. 5 red entries. A summary proceeding. You have been asked to go. You are relying on the case of Vijay. But subsequently, that same case, there is a on to the point judgment by the Supreme Court, wherein it says, if this is the manner in which it has been done, proper.
My lord, in my case, my lord, only so cause notice was given and kindly say reply to my so
We
cause
will
notice.
not go into that extent. We will not go into that extent.
And my lord, they have not done any inquiry, my lord,
No,
no
no.
hearing, my
There
lord.
is no requirement of an inquiry. It's a summary proceeding. You have been asked.
No, my lord.
And do you deny the 5 red entries? Have you disputed? 4 red entries have you disputed?
I deny, my lord, because
Haven't you not gone under these penalties? Have you said that the penalties which have been inflicted, 14 days rigorous imprisonment each,
penalty,
you have not suffered?
penalty they have given,
Then-
but my lord, kindly see that in the affidavit of question, my lord, they have given the, my lord, tentative search was given, my lord, annexary, then, my lord, they have the hearing of search, my lord, kindly see page 82 of their affidavit in opposition.
82.
Affidavit in opposition.
82.
Yes, my lord.
Yes.
Same day, my lord. This is not hearing, my lord. Same day, they have, my lord,
Show
kindly
me
see that
that you will have to be given a particular timely period for this. Where is the law?
82, my lord, page 82. Same
I've seen
day,
it. I've seen it.
November. It's not hearing, my lord, because I have not been given the
I
chance.
have seen it, madam. Now you show me that a particular time frame is there, period is to be given. Just show me that.
My lord, kindly see time. Hearing, my lord, as per rule 47, my lord, Assam Rifle rule. Hearing of charge, my
Assam
lord.
rifle rule amatar nice again.
Lordship, I have just, my lord, kindly see the
Rule
hearing of
40
charge, my lord.
Page 20, 2 May, I have sent in mail, Lordship. Page,
Give it to.
Even in, my lord, in their advisory, they have made, my lord, kindly see their own advisory, they have made, my lord. That also they have not followed. Hearing of charge, that was not done. I have not given opportunity of hearing, my lord. I have not given the opportunity to put my defense, my lord. Same day they have fill up the
You have
form, my
declined.
lord.
You have
That is-
declined. Madam Bora, you are making a very serious allegation. Have you made them by name, those parties by name? The officers who were there, have you alleged malafide against them?
My lord, decline, I have not written, they have written.
I know
Kindly
that.
say-
I know that. But have you said that these, have you made them by party, name by party?
By name, my lord.
Mr. Bhuya, you need not sit. We are reserving it because we will be not here from next week. We are reserving it. We'll pass the orders. Both the cases, we will be reserving it.
This is not, my lord, I have not got any chance, my lord. Simply they have first, and they have to see my lord condition. On which condition, my lord, I was absent on first occasion. Because after
That cannot be
submit-
looked into because those charges cannot be gone into because it has already been finalized. And you have not disputed those 4 charges.
No, I have disputed, my lord. Kindly see in my writ petition.
No, now, at that point of time. Today you can't do it. No? It's already final. That period is over. You have undergone the penalty.
My lord, but my lord, inquiry, my lord, they have not done, my lord. This is not inquiry, my lord. And
Summary proceeding, nothing more is required.
my lord, and kindly see, they have said me the incorrigible offender, my lord. And in my affidavit in reply, my lord, kindly see, I have all the judgment of Honorable Supreme Court, my lord. My lord, have the affidavit in reply.
When did you file your affidavit in reply?
Monday, my lord.
Not on record. Can you give me a copy?
On Monday, my lord, I have filed here, my lord, I have a more recent judgment, not Virendra Kumar Dubey also, and one more recent judgment, my lord, where it is clearly said, my lord, that inquiry is necessary, and my lord, incorrigible offenders means who are confirmed as bad characters, who are repeating the same thing. They have said, first occasion, my lord.
Okay, which is the judgment you want to follow?
First judgment, my lord, in my affidavit in reply, annexure 1, it starts from page 123.
This is Amarendra Kumar Pandey.
This is 22, July 22, my lord. I am only, my lord, 37 years, and I have completed 16 years, my lord. In my reply to the show cause, I prayed that let me complete my pensionable period 20 years so that I can get, my lord, VRS, my lord. And initially, my lord, I represented the department. I was a good boxer, my lord. At the international level, I represented the department, my lord. And after serving 10 years of service, my lord, in the year 2017 only, when my daughter was ill, my lord, I was not given leave, my lord. So she was admitted hospital. So I went to home, my lord. At that time, my lord, they have given me unauthorized absence, but they have not heard my problem, my lord. Without hearing my problem, they have, my lord, punished me. And secondly, also, my lord.
Okay, we'll go through this. You have nothing more to say with regard to this. You have already,
Lordship, we have already,
and the affidavit you have sent.
most of the cases, he's out of all, one is absent without leave, others all are intoxication. So in some cases, judgments, Lordship will found that the
Who
offences are
gives
also
him
different.
the ingredient for that intoxication?
Lordship, there is no any such reason. He had
No, who supplies him the ingredient so
Lordship,
that he gets intoxicated?
Lordship, we have
You
also
do it.
given, he had,
You do
Lordship,
it.
one he theft also.
My lord,
There is one allegation. Another is, one is local. And the others are, you gave him. Huh?
But in duty hours, etc., that is
Huh?
there.
You
He,
give them easy access and they do it.
Lordship, 80
This is
page,
not done.
88 and 90, he also admitted.
Okay, heard the parties at length. Also, raised it to list this matter again on 16/12/2024 as a parted matter. Madam, do one thing. Just give me a photocopy of this. Only this page.
Lordship, for this type of, for raid entry, 108 is applicable. These are not.
I know, I've got it. But Madam has raised
Lordship.
at least
Yes.
2 decisions.
Lordship.
Listen, we'll have to answer that. We'll do that. If she had not placed that, I would have proceeded to dispose of the matter. One more day.
Apply.
Yes, Mr. Subba.
Lordship, the petitioner was suspended, but no memorandum of charges furnished, Lordship. Suspended, Lordship, page 35, bite order dated 9/10/23. Thereafter, Lordship, bite order dated page 38. 8/1/2020.
Yes, any proceeding, Ron?
Lordship, I request some time, Lordship, because the board has new board has.
Forget
come,
it. New board, old board.
I have some instruction, my lord.
Huh.
Yes, my lord. Inquiry officer appointed.
Department proceeding when started?
Lordship, one thing is there.
When was the show cause notice issued to you?
That show cause notice 9/10/2023.
That is the suspension order.
Suspension order, Lordship,
Huh.
show cause notice, Lordship. 20 September, page 29. 20 September 2023, 2 show cause notices were issued, and page 30, 27 September 2023.
No, this is not show cause. This is not show cause. When, then next one?
Then next, thereafter, Lordship, I submitted my reply, page 31.
When is a show cause under?
Only that was.
My objection was there, first day objection was there.
Government employee.
Forget it. The notices that you have issued to him, he's under Article 12, he is a state, that body is a state.
Municipal board. He is
Municipal board.
appointed through a resolution law.
And his show causes are issued by the
Show cause-
Joint Secretary, Government of Assam.
Government of Assam.
Department
Upon receiving a complaint from
Be that as it may. Now, where is that proceeding? These are all why we will not initiate proceeding. Where is that proceeding initiated?
During pendency, Lordship, I have received
Inquiry.
1/10/2024
Hmm.
that regarding charge sheet of my submission that was submitted.
Inquiry was there.
Inquiry report I have.
Inquiry was there.
I have written. Inquiry report was submitted on 3rd April 24 to the DC.
How can you, the show cause was issued only on 110,
1/10 after suspension, Lordship, more than
more than a year.
year.
Yes, my lord. There, my lord, Ajay Chaudhary comes in. Para 23. My lord will read. I am reading, my lord.
There is already, I have read it and I have dictated also. It is reported now. That is no case. 23 is on a different footing altogether. 23, the Supreme Court did not give any relief to the appellant therein,
Yes.
because by the time the things were settled by the Supreme Court,
My lord.
by the time this law was laid down by the Supreme Court, the person was given a charge sheet. And he has been given the liberty to assail that, or even on the ground of para 21.
Continuous, my lord. That is what, my lord, my lord, I'm just reading, my lord. So far as the facts of the present case are concerned, the appellant has now been served with a charge sheet. And therefore, these directions, the para 22, my lord, these directions may not be relevant for him any longer. However, if the appellant is so advised, he may challenge the continued suspension in any manner known to law. Known to law.
Known to law is also para 21. Known to law is again para 21. I have already. First, my Lord Justice Borua, thereafter Prasanta Dotto, thereafter I have followed.
Prashant Datta, yes.
I have followed thereafter.
Yes.
I have followed.
In
And I have clarified
in
this fact
Prashant
also.
Datta, my lord, this charge sheet was, my lord, first thing, review was done after a period of 8 months. First review.
What is that inquiry report you are carrying? It's a preliminary inquiry report.
No, Lordship, after that suspension.
110/24.
110/24.
3rd April 20. 3/4/24, my lord.
What is that? Here there is no proceeding done till now.
Not.
No, Lordship.
Reinstate him, but don't give him in any. You keep him wherever you want.
Lordship is the
My lord,
municipal
it's a
board. It's a
Where
board.
will-
Where
Where
you
will
keep-
you send him?
Send him to your the main department.
No, my lord.
21 last
Not
part.
a
No,
gum-
that
he's
is
a-
the problem, my lord. He's not a government servant. He
He's
is.
Send him on deputation.
Where?
That also we cannot, my lord.
You can.
My lord, we cannot.
I'll ask him to consent. One year, nothing. Bro.
My lord, a notice was issued on 21/8/24.
আইজলত থাকাতে এটা সাসপেনশন মেটাৰ অৰ্ডাৰ দিছিলো সেই মোক এটা কপি এটা ওলাই দিছে যদি মোক বেকতো থাকিব পাৰে ভিডিঅ' অলপ চাই কৰি আছে যদি কৈছে
Lordship, let it
My
be on
lord,
next
grant-
week, Lordship. Let me
and
have
my lord
the
will grant us
sometime,
10 days
Lordship,
time to
because
file
I.
the affidavit. Let us bring this, my lord.
what affidavit will you file? Mr. Chetia, you need not wait. It may not be possible. I have made it CAB. Both I have made CAB. You have given your note. What will you add? Dispute? Then I'll give you time. Mr. Dhor, we'll take it up after some time. You just get your things cleared up. Huh? Oh, hey, interim order passed earlier to continue till the next date of listing. Item number, item 40. Yes,
Lordship, they have filed two affidavits today.
today.
One by the private respondent, another by the respondent number 4, and respondent number.
It was not there. It's not tagged up. Today they filed. Okay. It is stated, Mr. Bhattakur, learned counsel for the petitioner submits that the respondents number 4 and
2, 3, and 5.
2, 3 and 5.
Two affidavits, one by the
2, 3 and 5. And respondent number
2, 3, 5.
4. No, 2, 3 and 5 and respondent number 4 have filed their affidavits in the matter today. So, registry to list this matter again. You will file a reply.
I'll reply, Your Lordship, 2 weeks.
2 weeks.
time, Your Lordship.
Registry to list this matter after 2 weeks on a date to be fixed by it. Full stop.
If Your Lordship can fix it. if you-
Registry according full stop. The counsel for the petitioner is granted 2 weeks time to bring on record his rejoinder in response to the affidavits filed in the matter by the respondents. Full stop. Registry to list this matter again on 2 weeks of 18.
Lords.
But I think there are other similar matters also pending.
No, my lord, he has
Yes, tomorrow that matter is coming.
17, Your Lordship.
17.
17.
17. There is a matter coming up tomorrow. Same matter. R. Mojumdar. Remind us, we'll fix it on 17 together.
Deeply, Your Lord.
17, no? Yeah, I believe you, Lordship. My lord,
Lordship, here I have not received any instruction, Lordship, I pay for some time.
On the prayer of Mr. S.S. Roy, learned CGC. Mr. S.S. Roy, learned CGC, submits that he be granted further 3 weeks' time to bring on record the stand of the respondents by way of filing an affidavit. Proceed. Mr. S.A. Ahmed, learned counsel for the petitioner, is present. So, in view of the above, registry to list this matters again after 3 weeks, enabling Mr. S.S. Roy to invariably file his.
Lord, I am praying for a date. After 3 weeks, my lord,
Make a mention, we'll put it.
oblige.
Yes, Mr. Swigan.
But in this case, the petitioner to Lordship is a daughter, her mother died, my lord, on 17/10/2018.
Yes,
This was the direction of the Supreme Court to pay the, my lord, family pension, the compensation of family pension. It was paid, my lord, with effect from 1/5/2019. But her mother died on 17/10/2018. For a certain period, they have not paid.
where is the direction of this court, which is violated?
Page 19, my lord. They got 32 and 33, my lord.
Yes, what have you done?
Yes, Lordship, we have written to the Accountant General's office because whatever amount that has been sanctioned by Accountant General, we have released that entire amount. But since there's some amount lacking as per the petition, we have written to the Accountant General.
Not lacking, she is claiming family pension. You are getting family pension?
Yes, my lord.
You're getting? Only that thing is that 1 year gap.
Around 6 months, my lord, this year.
Yes.
So, Lordship, we have written to the Accountant General to sort out that issue because whatever has been sanctioned by Accountant General, we have released the entire amount.
What is the question of sanction here? Mother died on 1710. 1810 onwards, if she is entitled from 1810.
Yes.
Where is that doubt here? Either she is not entitled, or if she is entitled, she'll be entitled from 1810. That's all.
But
You have made the Accountant General a party here?
yes, they are party.
Who is appearing? Notices were issued.
Once, my lord, he was appeared in person also. My lord.
Who?
Accountant General. They wrote a reply to the register directly, my lord, that is why my person defense was given.
There is no reflection of his appearance in person. The advocate, Accountant General is respond number
4, my lord.
4.
My lord, sorry, my person, it is not the Accountant General, my lord, that's engineer, my lord,
What will he do?
under secretary.
It's not served. Respond number 4 is not served.
Take it face to face. In that case, my lord.
Check up. I don't find any service report here. If not, you take steps. Otherwise, this will not get resolved.
It's this one.
You just see. Yeah, here the few matters are there. You just see and tell me. Order sheet सब jumbled up हुए से. ये order sheet माने है note sheet की office note की can you mail me? Yes, Mr. Chaudhary.
May it be, my lord. We have following amendment of our cause title. We should notice upon respondent number 4. But who has
Notices have not been issued.
notices have been served upon him, but he has refused the action. My lord.
Have you filed an affidavit to that effect?
We have yet to file the affidavit. If directly we can file the affidavit.
You have taken steps by Dusty.
We have no, we have taken we have issued notice by registered.
Okay. Let us see what is the office.
But the respondent number 2 and respondent number 4, both are the same person, one person. And the respondent number 2, he has filed an affidavit in opposition.
Oh, no. Mr. Chaudhary, before on 2011-2024,
Yes, ma'am.
when the refusal before the Laujima court, Mr. S.M. Sharma has appeared before the Laujima court today and submitted that the respondent number 2 and 4 is one and the same person who represents as secretary so-and-so. In this regard, the petitioner wants to file an affidavit in support of their stand. Hence, the matter will be sent to the honorable court enabling the petitioner to file an affidavit. Why have you not filed that affidavit?
Because we are waiting for this order of this honorable court to file an affidavit.
So you mean to say the Director of Sports, Youth Welfare, Rudra Singha Sports,
Yes.
and Assam Secretary Assam Flying Club Society is one and the same?
Yes, same person.
Who is appearing for the Director of Sports and Youth Welfare? Madam, you are appearing for whom?
Lordship, I'm appearing for respondent number 3 and 5.
Yes. This is a government cooperative society.
It is a cooperative society, my lord, but primarily patronized by the government itself. The petitioners were ex-employees of the Assam Flying Club.
No, the thing is, if you have a dispute with regard to your internal matters, that is with regard to giving you the appropriate scale of pay, how can this court come in? The
Therefore-
scale of pay will be paid by the cooperative society to you. Nothing to be done with the government. How a writ would be
But
maintained?
we have got two problems, my lord. The ex-employees of the Assam Flying Club, numbering 9, they received their salaries at the intervention of the Honorable Court. As directed by the Honorable Court, they received their salaries in that area long back. But the salary was paid to them, not in the current scale, but in the old scale. Over and above. The Provident Fund money, which is their employees' own money, that amount of money, they are not been paid. So hence this is petition in fact. The Provident Fund money ought to be released to the employees, which is their own money. This is not being released. And salaries that are paid, they're paid to all scale, not to the scale.
It is said that the director and the secretary flying club is one and the same person. Can you receive notice then on the basis of the secretary also? Assam Flying Club. The director is holding the charge. Or should I require him to file an affidavit to the effect?
Let him file, because director, person may be same, but these are two different.
Different
entities.
organization.
It's a very in a different footing, directorate and secretary, madam. And I think this, whether they are still in existence, directorate and my lord, even retailers and all, flying club.
Flying, that is with regard to the ownership of the flying club. That has, they are employees. But the question is whether this issue can be agitated before a writ court when the payment, salaries are in question. Salaries will be not by the government.
We are not paying.
By the society.
By the society.
Not getting it, then a grievance against, per se against the society, whether a writ would be maintainable. Yes, Mr. Gugoi. Mr. Chaudhary, please examine on this matter.
My lord, that director as well as the secretary, that they are the same person, we have a notification, which will speak for itself, the director and the member secretary, that's implying the same person. Over and above.
We get it.
But what about the Provident Fund money, my lord? The Provident Fund money they can do.
This Provident Fund money is deposited in their own.
Yes.
There is own scheme.
Yes, my lord. That money has not been released to them. And
Heard Mr. J.C. Chaudhary, learned counsel for the petitioner. Also heard Mr. R. Dhar, learned counsel appearing for the
Number 2.
Respondent number 2. So also heard Ms. M.S.
T.R. Ovang on
Yeah.
behalf of S.K. Talukdar.
Oh, no, fine. Appearing on behalf of, appearing on behalf of the respondents number
3 and 5.
3 and 5. So, Mr. Dhar shall receive instructions on the next day. Mr. Chaudhary submits that given the nature of relief sought for in the present proceedings, the present writ petition would require an urgent early consideration. Mr. Dhar shall receive instructions as to whether he can also represent the Assam Flying Club Limited, right? Full stop. No, okay, no, cut it. Mr. Chaudhary submits, Learner Council for the petitioner submits that it is the Director of Sports and Youth Welfare today who is managing the affairs of the Assam Flying Club Limited. Accordingly, Mr. Thor shall verify the said contention of the Learner Council for the petitioner, and if the Director of Sports and Youth Welfare is so managing the affairs of the Assam Flying Club, he shall receive instructions as to why the payments due to the petitioners were not released by the Flying Club till date. Full stop. On the next date, the issue of maintainability of the present proceedings is is also kept upon, and the Learned Council for the parties would be at liberty to argue on the said issue also. Right.
Related matter you're looking. But there are two aspects of the order, Lordship. First, Lordship, to regularize the period of suspension, Lordship, and thereafter to release the deep encashment and gratuity, Lordship. The second aspect is the Lordship to release the final pension, Lordship. Here, Lordship, though they have released the gift salary and gratuity, Lordship, but without regularizing the period of suspension, Lordship. This they ought to have done as per the order, Lordship. And secondly, Lordship, they have not.
What was he? What was post was he holding?
He was holding my lord, machine operator, Lordship, assistant machine operator, Lordship.
Is this the first case he has filed, WPC 5910, or before that there are some matters?
Earlier also he filed, Lordship.
Did I appear in any one of them?
Yes, Lordship.
Huh? I appeared in any one of them in these cases?
No, Lordship.
No.
Lordship. Page 19, Lordship, para 12, Lordship. The direction for regularize the period of suspension, Lordship, and thereafter release whatever outstanding retirement benefits are found to be payable to the petitioner, including
What is this?
salary and gratuity.
He's getting the provisional pension, not for regular pension. We have written to the AG.
Okay. Heard Mr. D. Bhuya, Learned Counsel for the petitioner. And also you are for?
I'm for 1 and 3, Lordship.
And also so-and-so Learned Counsel appearing for the respond number 1 and 3. It is submitted that the revenue, no? Director of Land Records and Survey, Assam, has forwarded the pension papers of the petitioner to the Office of the Principal Accountant General, bracketed A&E, Assam, on 4/10/2024. Who is appearing for the Accountant General is a party?
Yes,
Part of the part,
Part.
service is not complete, Lordship. Number 6.
Okay. Service not complete. Also. Also, the office note, it is reflected. It is seen that the service, there is no, it is seen that the service of notice upon the respondent number 6 is not complete. Also, notices were issued in the matter way back on 19/7/2024. Accordingly, petitioner is directed to take fresh steps for service of notice upon the respondent's number. You are appearing for?
I'm for 1 and 3.
1 and 3. Respondent's number 2, you are appearing. 5. 2 also. 2 and 5. 2 and 5 you are applying. 4
and 6.
4. No, 4 is immaterial, not required. For service of notice upon respondent number 6, steps within 3 days. Full stop. Service of notice upon rest, so and so. by registered post with AD. Steps within 3 days. Registry to list this matter after 4 weeks, along with a report with regard to the status of service of notice upon the respondent number 6. They have sent. In the meantime, you take steps. 1 month it will take.
Obligatory.
Leftover get answer.
Lordship, we had got information that the petitioner has got his regular pension. But
See, he is receiving, I have the instruction of him. This basic pay is for Lordship, the present status of the PPO Lordship.
Where have you filed this IA?
As per their Lordship, statement made in the IA Lordship, they have not received the regular pension, so they have filed the IA in the dispose of writ petition Lordship. Otherwise, he is getting Lordship the area payment also he is getting. It's amounting to Lordship 23,18,226.
Counsel, how can you make this prayer in a disposed of writ petition, asking for status of the file a contempt if they have not done it?
Then Lordship, it was paid loss. He is getting.
That is different.
He is getting Lordship.
In the humble prayer, please to so and so further directed to submit the present status regarding issuance of PPO of the applicant in pursuance to the order dated so and so. What is this? What is this? See, it's very limited that in a disposed of matter you can have a IA, say for correction, something like that. If they have not complied with the order, or they had gone back, resiled on the stand taken and recorded by this court for disposal of a writ petition, file a contempt. Will you withdraw this?
Otherwise, his grievance is already complete.
That is different thing, but this is not proper.
But this is not maintainable, Lordship.
This is not maintainable, my
It is not
It
maintainable.
cannot be.
Lordship, Lordship, kindly fix it on next week.
No. Today. So, it is noted. I'll pass, I'll dismiss it. Don't worry. The present interlocutory application has been filed by the applicant, writ petitioner, praying for a direction upon the respondent authorities to submit the present status regarding issuance of PPO of the applicant in pursuant to the order dated 27/3/2024, passed in WPC number 6408/2023. It is to be noted that the said writ petition was disposed of by this court wide order dated 27/3/2024, and accordingly, in the event if there is any violation of the directions contained passed by this court wide the order dated 27/3/2024, it is the petitioner is the applicant is at liberty to file appropriate application against such violation of directions passed by this court. The present interlocutory application cannot be permitted to be so filed. The present interlocutory application with the prayer as noticed herein above is not permissible to be filed in a disposed of matter. So accordingly, the present interlocutory application stands dismissed.
See, I am appearing for
Mr. K. Gogoi, Learned Counsel, Learned CGC appears for the opposite parties.
Lordship. Obligable. Obligable.
Lordship, instruction have been received. May your Lordship kindly grant us some time to file an affidavit.
Yes, what is your grievance here?
Lordship, a petitioner was punished by the authority without providing any opportunity of hearing, Lordship. In this, without serving any shockers notice, he was punished, Lordship, by the authority. And he was taken into force.
Again, I don't know, Arun Chandra Kolita.
No, Lordship,
Arun Chandra Kolita.
Abdul Mathur,
48.
49.
48. That's what I was saying. What is this? 48. 48. Hmm? Hmm? It was 90.
48 lordship already dismissed lordship, that IL lordship.
Okay, huh?
Things.
Things.
Was in respect to item number 2 lordship. Item number 2 delivery of order lordship.
After this, if I can get, I'll do it. Otherwise, I'll pass some.
I will be not here.
No need.
Oblige lordship.
Yes, what is that? This is WPC. Yes.
Lordship. In this case, earlier notice was issued.
Yes, you have filed your affidavit.
No, Your Lordship, we have received instruction.
Okay. Madam, your name?
M.K. Sharma.
MS M.K. Sharma, Learned Counsel, appearing for the respondents, submitted that the instructions have been received from the respondent authorities and the affidavit would be filed by date.
Lordship, 3 weeks.
No, date. Give me a date.
3 weeks.
By dash, full stop. Accordingly, the Learned Counsel for the petitioner is present. Mr. L.R. Mojumdar is present. Full stop. Registered to list this matter again on Etur Ekhopta Pisha.
Online.
Affidavits are not coming. We are just coming here and adjourning matters for affidavits. That cannot be. Either you file it on that day or we will proceed with what is available on record. Maribu, who does it? That similar order you have not got, na? Mr. Bhuyas? Have done. My order. Same issue. Same selection.
2013 selection.
Mr. BK. This is the one. This is the one. I was trying to get this. Okay. Disposed of. Disposed of. Yes.
Please, Your Lordship. My lord, as per Notary Act, my lord, the notary.
What do you have to make further submissions?
No, my lord. One point out, my lord.
No. We'll have to have everybody then. You are paying for the petitioner.
Yes.
Heard you. If you have something more, that let us have everybody then make that submission. No, I'm not stopping you from making submissions, but in absence of the respondents, there is a private respondent also. So let them come. This is with regard to that talak. In before a unregistered talak.
My lord, before notary.
That cannot be.
My lord.
Because at least at that point of time, the Assam Muslim Marriage Divorce Act was in force.
My lord, in force.
So if that be so, then it is that procedure under that act.
My lord.
If you want to argue.
No, my lord, I have no problem.
No. But still. Because they are also not too much tied up. Two people. Mr. M. Islam, Learned Counsel for the petitioner, submits that certain further aspects he would like to highlight upon certain further aspects in the matter before this court. So it is seen that the respondents are absent, are not present, maybe under the impression that the orders would be passed in the final orders would be passed in the matter. So in view of the above submissions of Mr. Islam, registered to list this matter again on 17/12/2024 for further hearing. I'll pass the orders in.
Highly obliged, Your Lordship.
52. Oh, Yes. Yes, yes.
1122, my lord.
Huh?
1122, my lord.
Withdraw.
No, my lord. That in 1122, my lord. Pension was granted, my lord.
Huh?
Pension was granted, my lord,
Huh.
from 1122, my lord.
Then,
Yes, that amount will be deducted from this amount. The pension amount.
okay, we'll deduct that. That'll do.
Lordship, madam. That pension amount should be deducted.
1122
31, 12, 22. That period amount will be deducted.
pension paid. So you agree? We'll pass a short order.
My lord, my lord.
Huh. Who's up? Heard Mr.
Yes, sir, Ahmed.
HR Ahmed, learned counsel for the petitioner, and also heard Ms. MS
MD.
MD Bora, learned counsel, appearing for the
1, 3, and 4 Fishery Department.
fishery, standing counsel fishery department, appearing for the respondents number
1, 3, and 4.
1, 3, and 4. Who's up?
6.
Also heard Ms. So-and-so, learned counsel, standing counsel, appearing for the respondent number 6. Who's up? As agreed to by the learned counsel for the parties, comma, the present writ petition is being disposed of in the following manner, with the following directions. The petitioner hearing while serving was recruited as a fishery demonstrator on 4/4/86. Full stop. At the time of his initial appointment, in the service book so opened in respect of the petitioner, at the time of his initial appointment, his date of birth therein came to be recorded as 23/12/1962. Full stop. Such date of birth was so recorded basing on the HSLC pass certificate submitted by the petitioner. Full stop. In the HSLC pass certificate, the age of the petitioner as on 1/3/1978 was recorded as 16 years, 2 months, 8 days. Full stop. By recording the age of the petitioner as recorded in his matriculation certificate, comma, his date of birth works out to 23/12/1961. However, the respondent authorities erroneously recorded. Basing on the said document, recorded the date of birth of the petitioner as in his service book as 23/12/1962. The petitioner continued in his services in terms of the date of birth as recorded in his service book and retired from his services with effect from 31/12/2022. Full stop. The petitioner full stop. The respondent authorities thereafter, while processing the matter for submission of for finalization of his pension and pensionary matter, detected the error committed in recording of the date of birth of the petitioner in his service book as 23/12/1962 in lieu of 23/12/1961. Accordingly, the matter was processed and a decision was arrived at to recover from the pension and pensionary benefits of the petitioner the salary so drawn by him beyond 31/12/2021. First up, accordingly, the Principal Accountant General bracketed A&E Assam, White PPO, dated White PPO number 1006311307454, dated 22/8/2023, finalized the pension and pensionary benefits of the petitioner, and therein recovered an amount of rupees 9839.76, right, from the pension and pensionary benefits of the petitioner. So, accordingly, being aggrieved, the petitioner has approached this court. So, today, when the matter was taken up for hearing, the parties to the proceeding have agreed to the fact that the salary drawn by the petitioner beyond 31/12/2021 till the date he had retired, that is till 31/12/2022, cannot be recovered, may not be recovered, and he be permitted, and the period be permitted to be treated as re-employment. So, the said agreement is reasonable and in tune with the directions of the Honorable Supreme Court, Honorable Apex Court, Supreme Court of India, in the case of Rafiq Mashik. Rafiq Mashik, whitewasher, citation to Asil Tumar, 2015, 4 SSC 334, and other cases in this line. Full stop. However, Ms. M.D. Bora submits that the petitioner has been authorized his pension with effect from 1/1/2022, and further the period with effect from 1/1/22 till 31/12/22, having been permitted to be treated as a re-employment, and the petitioner already having drawn his salary for the period, the pension which has been so sanctioned to the petitioner for the said period is required to be recovered. So, the said prayer is not objected to by the petition counsel for the petitioner. Accordingly, the pension drawn by the petitioner with effect from 1/1/2022 till 31/12/2022 in terms of the PPO dated 22/8/2023 shall be deducted from the amount now required to be repaid to the petitioner against the recovery made in his case towards overdrawal of pay
Yes, ma'am.
for a period beyond his actual date of superannuation, shall be so done, and the balance remaining shall be paid to the petitioner within a period of 2 months from the date of receipt of a certified copy of this order by the respondent authorities. So, with the above observations and directions, the writ petition stands disposed of.
My lord, for 2 and 7, P. Naik is appearing.
Miss and Mr. P. Naik, learned counsel, appearing for standing counsel finance, appears for the respondent number 2 and
6.
2 and 7. Ms. Bora, if you don't get these orders in a day or two, there is a jump. You will get it next week, Monday. Monday mane pai jabu na? By Monday. Monday or Tuesday you'll get it. Tell him also. Yes.
My lord, it is, may I pray for some time, because
On the prayer of Mr. U. Dr. Learned Counsel for the petitioner, registry to list this matters again after 6 weeks on a date to be fixed by. You don't want a disposal. I was about to allow the matter in your favor.
Well, Lordship, I have find one judgment, Lordship, but I want to.
I don't want. I just
then-
just getting myself freed up so that I can pass the order.
Then, Lordship, I,
No. Now I have passed the order. You have missed the bus.
Lordship, day after tomorrow.
I wanted to allow it. I was just.
I also didn't get time to check up.
Get it. You will not get it.
Lordship,
Anything
I
contrary.
try to find out.
Right.
Lordship, can it be there?
I was convinced. I was about to allow the writ petition in your favor. Next day, sometime, if it comes back to me, I'll take. Not today. If you ask for an adjournment,
No, Lordship.
when you are ready to get an order, I am very eager to pass that order.
No, Lordship, I try to find out the immediate.
You need
fact
not.
and that part.
That is a settled position of law.
The Lordship just indicated that.
I wanted you to do some research. That's why I asked you. Yes. Yes, you have filed an affidavit.
Yes, sir.
Ah. And therein you have said that the scatter strength is 322.
Total is 222.
322.
322, sorry, 70 reserved.
Hmm.
And then 20 already filled up. For
How
70.
many people in man in position?
Right now,
Huh?
Lordship, right now only 17 posts are vacant.
Not on that. At that point of time,
Yes,
there was 191. You were promoted in 2010.
2009.
9. Okay.
But
10.
it was cancelled, my lord.
Forget it. Why it was cancelled? It was cancelled because they were promoted against
Reserve
quota
category,
posts. Huh?
backlog post. Yes,
That
my
is
lord.
why I passed that order and now you have complied with it.
Yes, my lord.
Now tell me, come to page 114.
Yes, my lord.
Cadre strength 322.
Lordship.
As of 2010, we are not concerned today. We are concerned with 2010 because 9 they were promoted. 195 in position and 28 out of that are backlog.
Backlog.
So as per roster, 322 numbers, then 70 numbers has to be reserved for backlog. Now mind your words. As per roster, if cadre strength is 322, then 70 numbers has to be reserved for backlog.
Yes, my lord.
In the matter, it is observed 42 backlog posts are still vacant. Hence, the 25 number now are included in 45 backlog, for which had accorded approved for fill.
Lordship.
Now, you have promoted them,
Lordship.
right? You have not filled up the entire cadre post.
Yes.
As of 2010, only 195, including 28, maybe they, who have been promoted. You have not filled up the cadre post. Where was the occasion to revert them?
Because the petitioner is not belong to the backlog category.
Madam,
my lord.
that backlog, even if they are promoted, backlog vacancies, still there are posts wherein they have been. You have not identified that these are the persons who will now be promoted. There is none you have identified.
As per the
Have you identified? You have cancelled this promotion.
yes.
Thereafter, have you promoted anybody?
That instruction I
Then-
have, Lordship.
Then,
But Lordship, may kindly have a look my affidavit, first affidavit.
but you forget your affidavit. That's why I wanted this instruction. Now, this is very clear.
Page
They were
97.
promoted. They are not disturbing any backlog because 322 minus 195, how much?
Lordship,
7.
page 97 for a moment, a letter issued by the finance department.
129.
322, 195. You want right?
See?
22, 195.
127.
The Lordship may fix the matter some other day. I will
No,
do
today.
the homework.
Today. I have come prepared. You explain.
No.
320. So you have balance of 127 posts in the cadre. Excess of 48 that you require.
70 reserve, 20 are already fill up, then 70 minus
45.
20 is 42.
42.
42.
So for
25
42,
impugned posts, we have promoted 25 number of posts. That we have cancelled later on,
That-
except 3.
no. 25 is included in 195.
Yes.
Where Lordship got the 195?
That it is observed that there were 195 men in position. Para 2, second line.
From the-
Arukita, sir.
195 men in position.
Including 28 backlog, which they are there. As per roster, if the cadre strength is 322, then 70 numbers has to be reserved from backlog.
Backlog.
In the matter, it is observed 42 backlog are still vacant.
Yes, still.
So-
working.
Post is also there. How can you interfere with their appointments?
Yeah, Lordship, that
So if he gets that back, he gets back everything. If he
page
bec-
97, my lord. Page 97, the finance letter, my lord. Lordship. Regarding the promotion, we have to give preference only to the that backlog 4,
Where?
serial number 4, my lord.
All backlogs in so and so. This is you do it. Who is blocking you?
Lord.
Even if you promote them, Backlog still can be taken. 127 posts are vacant.
Lordship, one day, Lordship, I will get that instruction.
I'll forget.
Friday? Friday, my
Friday,
lord.
impossible.
Then my lord may keep this matter as part heard.
No, no. I'm sorry, Mr. Sokia, let her have her instructions.
Let's keep the matter as part of.
No, no, I don't know when I'm coming back. Heard Mr. Ayat Sokia, learned counsel for the petitioner, also heard Mr. M.D. Bora, learned counsel appearing for the standing counsel, transport department, appearing for the respondents. Ms. Bora submits that she be given 2 weeks' time
Lordship.
to receive instructions with regard to the fact, with regard to the disclosures, with regard to the queries made by this court, query raised by this court as to why, when there were enough vacancy, enough posts vacant in the cadre of Laskar, for accommodating and or liquidating, for liquidating the backlog position with respect to the reserve communities, the promotion of the petitioner was required to be interfered with.
Sure.
So, raised it to list this matter again on Twelve, 2024.
12, my lord.
You place that instruction.
Lordship, that instruction, may I discuss on that.
This is what the position is. Anything more? If he gets back Laskar, he gets back everything. If he doesn't get back, he gets nothing.
Let's challenge any order. This
Why?
cancellation also, the
That is
captain
after
Evans
the
order,
captain-
nothing.
That cancellation is or after my retirement.
Whatever it may be.
Wait,
but
no,
he-
how?
He kept quiet for.
I
30
forgot that. I
minutes.
forgot that. Cancellation is of 22. I
But
can even
the-
proceed today on the
this
date.
happened in the year 2010. We have Captain Evans.
Abeyance is different, madam. But on the date he retired. So today, if we say that the abeyance order and the reason for that, because you said that post should be filled up by backlog, that posts were eaten by them. I'll use that word to get it clarity. He has not eaten. There are posts
There are
available.
vacancies
Then
posts are lying there. Yes. I'm also thinking in that line also. Also, I'll get instructions.
that is why in the last order I wanted that. Now it's very clear.
My lord. Obliged, my lord. 41.
Yes. Have you filed your, Mr. Roy, have you filed your affidavit? No. That Jyoti
one.
Prasad. Yes, what to do? Good gole. Isolate diya tum.
My-
Tumi
my
eta
lord-
disila niki tumi copy eta? Na isolate je suspension order eta ami pass korisilu je. Allow korisilu suspension order to ami korisilu. Ikhane ki আছে? Tumi মোক সিদিনা ওলাই দিছিলা এটা PWD. মোৰ তাত আছে.
Lordship, let us give us some time to file our affidavit. Lordship.
What will you develop by filing an affidavit?
My lord, I just want to place only this one small judgment, my lord. Before lordship, then if my lord doesn't allow me also to file affidavit, I have no, my lord, submission to make. This is what, my lord, the honorable division bench felt when, my lord, there is a case of corruption. My lord, if somebody, my lord, a government servant is, my lord, suspended or allegation of corruption, the state has a right to file an affidavit.
Prasanto Datta has been decided.
This is a division bench order, my lord.
Prasanto Datta has been decided.
Decided.
Who prevented you from filing an affidavit? We did not. The only question, law point that I am raising is,
My lord.
in view of the fact that the petitioner was suspended a year ago,
My lord.
whether after a year the suspension order sustains, in absence of any extension, even if I give you that liberty,
My lord.
extension, which is not permissible,
My lord.
you have nothing. You've not brought on record anything.
That is what, my lord, we want to file an affidavit. My lord will record my statement and my lord will pass an order. I have no issues.
We will pass an order by recording your statement.
That only that, my lord, I have received instruction and I want 1 week time to
You
file an
place the
affidavit.
instruction before me.
My lord.
There has to be a limit, Mr. Keeping a man under suspension 1 year, feeding him, you are doing disservice to the society.
Maybe, my lord, if the affidavit comes, it might help the petitioner also.
There is no proceeding initiated, Mr. Thorpe. Your own reply. Come to para 8 and 9. As such, the chairman to so-and-so was requested to initiate proper departmental proceeding against so-and-so as per provision of law. Wide this order, office order dated TCA. And this is by whom? District Commissioner. Who is he? Who is he? It is for the board. It is for the board. Is he the appointing authority, the district commissioner? Then you have Ajay Chaudhary with you. Judgment, copy.
Lordship, print, that copies of the state online printed copy also.
Yes, Mr. Dhar. What is your answer to that? You are neither an appointing authority, nor you are the appellate authority. You are nothing.
Last paragraph.
No. So, we'll interfere. We will say that the proceeding now instituted will continue without prejudice, and you will conclude. This was produced by you. You will not, you will keep him in a post, right? Which is non-sensitive in nature.
They will.
Keep him in a post which is that much I'll provide. Given the allegation and the apprehension raised, we will provide that he will be kept in a post which is non-sensitive in nature. That much will do.
This much will do.
And we will record your submissions, that you have made submissions on behalf of the Deputy Commissioner, but we find that you are neither an appointing authority nor an appellate authority. And accordingly, we have refused to accept your prayer for filing a written statement.
That board has been changed by.
Board has been changed. What can we do? Board is a perpetual body. Or do one thing. If you want to file an affidavit, can you file it by tomorrow? Day after tomorrow, I'll take it up.
Yeah. Next week, Lordship.
What do you say?
Lordship.
Both their faces have fallen down. I don't like people going with this fallen down faces.
No, my lord. Why really I wanted to file an affidavit, my lord? I have the enquiry report. There is no, the enquiry report itself, my lord, gives him, my lord,
Clean sheet.
Clean sheet. That is why I wanted to bring it.
That enquiry is of no use, because that has to be done by the employer. Yes, what do you say? When can you file your affidavit? Tomorrow, day after, Friday?
By next week, Lordship.
Monday? Both of you, fine. Monday.
No, since deceased, my lord.
No party. That's why I said. You want to file or I'll close it? I think we better close it. Disposed of. If you don't get the order by Sunday, you'll get it on Monday only. Because they'll go away.
There is no service.
Hmm?
There is no edit card did not return, my lord. No answer notice also returned. In the meantime, my lord, the accountant there is also, my lord, he has got a new incumbent has come. So, Basil, if it's a matter on next Friday, in the meantime, my lord, I'll file a, my lord, implementing petition. But
I'll just adjourn it. It was all haphazard manner, the order sheet
Yes, yes,
submitted. On the prayer of Mr. Ayat Swikal and a counsel for the petitioner, raised it to list this matter again
next Friday, my lord.
on 6/12/2020.
Obliged.
आगे बात सुनिए। रिजर्व का कितना बोला क्या ऑर्डर डी बोला कितना था क्या? हाँ 3टा ठीक है।